Yes, may I, Your Lordship? Your Lordship, item number 740 of monthly list of July, Your Lordship. The private respondent has erected an illegal construction by blocking my ingress and egress road of my house, Your Lordship, which is the one and only ingress or egress road of my house, Your Lordship, by which, Lordship, give the number.
May your Lordship's kind indulgence to mention two matters, my lord, for extension of interim order expiring on 31st of July, my lord. Lordship, I have enclosed the server copies of both the matters.
Extension of interim order.
May I have Lordship's kind leave to mention item number 673. Lordship, there is a very short point involved. This is for implementation of an order passed in an earlier round of writ petition. Lordship was allowed in the previous occasion. Lordship, it appeared, but for that week, Lordship did not sit. And thereafter, it is appearing as 673. Lordship will kindly.
My lord, may I permit it to mention, my lord, for group 7 matter for considering, has not considering the authority of route number 202. That the vehicles which was not considered in case of petitioner has been sanctioned.
My lord, may I be permitted to mention, my lord, 3 matters, my lord, where the land was acquired. My lord, but that has not been demarcated. For that reason, the state government is encroaching my land, my lord. That is for upgradation, my lord.
Lordship, may I permit to mention
The monthly list?
Yes, yes.
Lordship, may I permit?
Contempt
Tinte
application.
monthly.
Yes.
Lordship, may I permit to mention?
Non-prosecution. To be mentioned.
Lordship, may I permit to mention one upgradation of monthly list item number 349, unauthorized construction over the state highways, my lord.
Give the number.
May I permit for a mention, my lord, upon notice to the opposite party, my lord, a 2018 matter, listed motion, my lord, for inclusion in the list. Inclusion in the list.
What is your urgency for inclusion?
No, urgency is, my lord, unauthorized construction already further constructed by the opposite.
Give the number.
May I have
Well,
Lordship's kindly for, I'm mentioning for link, Lordship, for Mr. Shoktinath Mukherjee, Lordship.
Which matter?
Item number 32.
My lord, may I be permitted? May I be permitted to mention a matter, my lord, for extension of interim order, my lord. The interim order is expiring tomorrow. My
Give
lord,
the number. Give the number.
this man-
Extension
matter-
of interim order. Yes, call the raised. Supplementary list. কিছু যা আছে তাই দাও। এইরকম দেখি। Item number? Yes, let him wait to be called. Let him wait.
Contempt application.
Item 1.
I'm for the petition.
Contempt application. Give the number. Yes.
of India, my lord.
I'm for the petition, your lordship.
I am for the National High Authority concern.
Why to be mentioned?
Your lordship, on the last occasion, there was some mistake, the cost title. The order went, it should be 2022, it went to 2020.
Oh, it's that matter.
National Highway, I mean.
An order was passed on the earlier occasion,
Yes.
isn't it? So
The
let
order instead of, it should be of the repetition of 2022, it went 2020. That's why the cost title, the 22 matter was running, your lordship, not this matter. Last day, item number 27,
this will be 2022.
2022. 9/2/60 of 2022, and the order went 2020. That's why there was.
So let this be corrected. কি অর্ডারটা ছিল আমার মনে হয় না তো। জয়ন্তকে একটু জিজ্ঞেস করবেন তো কি অর্ডার আছে সেটা তো আমাকে একটু বলবেন তো। I'll pass this to you.
My lord, on last occasion, my lord was pleased to direct me to appear on behalf of the National Highways Authority because no one appeared on behalf of the. Now, my lord,
2 times, my lord, appeared. Bhokaradana was submitted, appeared, my lord. When the matter was called on, immediately I appeared before your lordship and stated the interface. Then your lordship directed, yes, next time your name should be recorded. Actually, I have been appointed and Bhokaradana has already been submitted. And last occasion, my lord, I have not appeared, but earlier occasion most probably appear. I have submitted the Bhokaradana. It is my mistake earlier occasion.
False title correction করতে হবে। আমি একটা ডেট হুম
But as per your lordship,
Fix করে দিচ্ছি, ডেটটা মিলিয়ে ফেরত না।
on the last date, your lordship has passed a necessary order for the correction, I suppose.
Disposed of. This is a disposed of file?
No.
Pending matter.
Pending matter, not disposed.
Let it appear on 17th August. I'll do the necessary corrections.
My lord.
My lord, then my lord, my name should be regularized, my lord.
August.
My lord,
আমাকে একটু আলাদা করে দেখা যায়।
my lord, I have submitted the Bhokaradhanama. My
Give your name, give your name.
name, I have given.
If you want to continue along with him, you can.
My lord, lordship can pass these directions, lordship, so that I can assist your lordship. Otherwise, lordship, I retire. If your lordship said, I will,
It's already there.
my lord.
So unless I ask you to retire, no question.
My
Let him
my
assist you.
My,
No problem.
my, I will assist your lordship.
শুনুন আমি রেকর্ড করবো। জয়েন্টের কাছে আছে। এটা আগের দিন অর্ডার করা হয়েছিল, জয়েন্টের কাছে আছে। জয়েন্ট করবো। শরীর ঠিক আছে এখন? বেটার? কথা বলতে পারছেন? 17/8. Item 2.
I am appealing for the petitioner, my lord.
Yes, what is the correction required?
Correction, my lord, state. Yes, yeah, para 4, my lord, the petitioner.
Yes.
The petitioner contended they have been running a business in the name and style of Asar Podi, but be corrected and to be read as Trivedi.
Page?
First, my lord. First page, para 4.
Para?
4. Order sheet, my lord. The petitioners contended that they have been running a business in the name and style of Asar Podi Brickfield.
Yes.
To be read as my lord Trivedi. Trivedi Brickfield. And cost title is my lord correct.
It is not Asha Pradeep Brickfield.
No, Trivedi.
You have stated that in your writ petition?
And Trivedi Brickfield, my lord, also at the top, my lord, can you see Trivedi Brickfield.
So
738 was my lord.
There are two they have stated.
Where is it stated in the writ petition?
Paragraph 2, madam. Paragraph 2.
Paragraph 2.
Yes.
Oh, Triveni Brickfield.
Yes.
Trivedi Brickfield. Instead of Asar Podi.
You are the petitioner.
Yes, my lord, I am.
The matter has come up under the heading to be mentioned at the instance of the petitioner. Paragraph inadvertent error has crept into the order passed on 12th July 2023. Paragraph in paragraph four of the first page of the order, comma, Ashar Pradeep Brickfield be read as Triveni Brickfield.
Trivedi.
Paragraph, the department is directed to incorporate necessary correction accordingly. This order paragraph, this order be treated as part of the order passed on 12th July 2023. আশার প্রদীপ কোত্থেকে পেলেন নামটা? এটা আপনার করা ত্রিবেদী বলা আছে সব জায়গায়। Next.
Get.
Item 3.
That's you, I am
The statement.
There's a small typographical mistake in ordering portion, page 2.
Yes.
Second last paragraph. It is submitted on where the state respondent that the fifth respondent be correct.
This should be fourth.
No, this is correct. But second, last paragraph. In view of the above, the writ petition is disposed of by directing the respondent number 4. It should be fifth.
This should be fifth. Yes.
Yes, ma'am.
The matter has come up under the heading to be mentioned at the instance of the petitioner.
Yes.
Paragraph inadvertent error has crept into the order passed on 16th June 2023. Paragraph in the last paragraph of the second page of the order, comma, the fourth respondent be read as the fifth respondent. Paragraph, the department is directed to make necessary corrections accordingly. একটা লাইন ওটাতেও অ্যাড করুন, the remaining portion of the order shall remain unaltered. দুটোতেই এটা অ্যাড করুন। আর দুটোতে urgent certificate website করুন। Item 4.
Live vectors. But in this matter, I can on behalf of the petitioner, the contempt petition under Group 7. This matter was taken up.
পরে contempt গুলোর পরে
একটা পার্সোনাল অ্যাপিয়ারেন্স আছে ডিএমএ, একটা পার্সোনাল অ্যাপিয়ারেন্স আছে, সেটা ডেকে দেবেন কন্টেন্ট গুলো পর।
Well, the first time the matter was came before your lordship, before his lordship, the honorable justice.
It's appearing for the first time.
No, second time, because the matter was appeared on 26th August 2022 before his lordship honorable justice Taludar. Now his retirement, your lordship on with the direction the matter will appear on 16th September 2022. Personal direction of the honorable court copy was served. This is the evidence service. And check up the evidence service. Mr. Sen is appearing on behalf. Today I talked with over telephone, but he's coming. But I got the receipt. Yes. Well, even after receipt of order, kindly see the order at first.
RTA Nodia was the fourth respondent.
Yes. District magistrate and also secretary, because there is a direction upon the respondent two, that is RTA, that means chairman as well as secretary.
Where is the service on the contemner?
Yes, madam, I have next document.
You have served the learned counsel who you do not know.
The direction upon the Mr. Sen. Kindly see the direction much later. I have annexed in the first time because Mr. Sen is appear on direction, my lord, to serve the copy upon the kindly see the kindly check up the order of this honorable court. As the Mr. Sen appear publicly in my lord, directed the.
Yes.
This last occasion, my lord, direction of the Honorable Justice Supervisor, he has served the copy to us. But 1 week time is required to collect the instruction report. Within 1 week, I submit. I submit report 1 week, actually.
Well, short date can't because the matter is pending since long. Since 2021.
Learned counsel for the alleged contemner seeks accommodation to take instructions in this matter. Paragraph, let the matter appear under the same heading on 18th August.
My lord. My lord, my lord can direct to place the compliance report.
He wants
If
to
it
take
is-
instructions.
Also instruction.
If it is complied with, please come back with your compliance report. Next. Item 5.
I am applicant lordship. File for recalling the lordship.
Yes.
I am for the applicant. I filed one application and complete my argument or submitted notes of argument. The petitioner has obtained the order by suppressing the number of all the facts. That is why my point for recalling the order.
So this should take some time.
No, I was giving my reply. I was halfway through my reply. I'll take another 10-15 minutes. Just 10 minutes.
Because next 2 weeks, I have a circuit bench at Jalpaiguri. So will you start after I come back?
I can conclude in
I
10
do not want
minutes
to
time.
keep it piecemeal.
I just want to show that the diabolic fraud committed on record by the coal company before your lordship. Change of dates all
Yes.
prepared in the administrative kitchen. Complete diabolic fraud played on the court.
Because I do not want to keep it pending for the week. Please come back after.
As you
Yes.
Then after 2 weeks.
Yes, yes. Heard learned counsels for the parties. Let the matter appear under the same heading on 21st August.
Lordship.
Item 6.
I am for the petitioner, my lord.
My lord,
Well,
it is matter Sushobhan Sengupta
yeah.
appearing for the alleged contemner, my lord.
Kindly see the
He is
order passed
coming,
by.
my lord, I am paying short passover, my lord.
Passover is not.
My lord,
possible.
kindly see the last order, my lord. In the
My lord,
past
kindly
appeal,
make
my
it
lord.
not today, my lord.
My lord, your lordship direct them to file a compliance report because my lord, they prepare an appeal, my lord. Appeal was dismissed. Kindly see the order, my lord. Last occasion, your lordship adjourned the matter on the plea, my lord, the appeal is pending, my lord. ওটা বললে হবে না।
Yes, where is the compliance?
Well, I am paying only short pass. He's coming, my lord. My instruction, my lord.
Not today. Let him come back tomorrow.
Grateful, my lord.
Please come back with the compliance report tomorrow. Otherwise, rule will be issued. Next. Item 7.
I brought the petitioner. But adjournment was taken by my learned friend for compliance of the order. Kindly
It's
sit.
appearing for.
I am on behalf of the alleged container.
Yes.
Mr.
Where is your
Pavitra-
compliance report?
No, I have already made the complaint. I am led by senior advocate Promit Kumar Rai. He is online.
Yes, Mr. Roy, where is your compliance?
Yes, my lord, kindly consider, my lord, we have filed an affidavit saying that, my lord, there are certain discrepancies in the submission. We need some time, my lord, to examine and comply with. My lord, why prayer was made by way of an affidavit, my lord, that has been filed. If, my lord, that's true, but kindly see. Yes, but kindly see the difference. We have paragraph 15. No, my lord, that's entirely for my lord, my lord. I on behalf of the authorities cannot say. See, there's a discrepancies between the drawings. My lord, 3 things they have to submit, my lord. A drawing, yes, my lord, sufficient time has been granted. I have got nothing. But my lord, they say the departmental people came and they say if a prayer can be made, my lord, because we have not appealed and etc. We are trying to comply with. But my lord, so far as the building construction is concerned, there's a discrepancy between the drawing submitted and the structural report. This is one. And number 2, my lord, that so far as the records are concerned, my lord, there's another anomaly. So this requires some time, my lord, to scrutinize and to come because.
Have you considered the representation of the?
Yes, we are considering.
Yes,
They came. We are in the process of. They came. We sat. And there is a it's not that we are obstructing this. Ultimately, after 2 hearings, they've supplied all the documents. There's a discrepancy between the plans submitted and the structural report. We are considering, we are doing it. But my lord, in order to do it by application of mine, we have to see the structural stability of the building because it is near the railway line. That's the reason this prayer is very. It's not to, my lord, delay the process. Almost we are in touch and we are trying to find out the way how to pave the way out, not to obstruct the course of justice at all. That's the reason.
That's correct.
Yes.
So how much more time do you require? How much more time do you require, Mr. Roy? Another month?
60, my lord, we have prayed for 60 days time.
And
It is too much, my lord.
Yes,
Mr.
my
Roy,
lord,
another month?
2 months. My lord, 2 months is prayed for. I leave it to my lord.
1
2
month.
months is prayed for. Yes, I leave it to my lord. My lord. Clients.
So why are you submitting this affidavit of compliance today? It's not an affidavit
This is
of
not the
compliance.
compliance, my lord.
This is not compliance. It's building. Learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on. Very well, 30th August. You get more than a month. Paragraph affidavit of
30th August,
compliance be submitted on the
30th August.
30th August, 30.
Date for
Next.
Item 8.
I put the petition. The
Hello.
authority has passed an order related, passed an order that is to be challenged. That is to be challenged,
Action.
contempt application becomes infractual because of the order. Now they say they have not acquired.
They have?
Food department says we have acquired. Land acquisition department says we have not acquired. Well, this is the position now we have been facing.
Your lordship will come.
Have you received a copy of the?
Yes, ma'am. I have.
Combine the order.
Well, I have to challenge that order, ma'am. I have to challenge. Well,
So the
kindly come to-
representation has been disposed of.
Yes, madam.
Well, kindly come to the order once, madam. Page
Yes.
11.
Yes.
Huh?
হ্যাঁ,
acquisition বলছি,
page 13, my lord, last paragraph.
Yeah.
All are righty land.
Righty land you have acquired as constructions. Other department says you have acquired. We have received notice. We have to challenge now.
This is a notice of hearing. Hearing was fixed on 13th July. Where is the order?
Yes, after the expiry of
Oh,
the
after
time.
this, after
Page
this.
13, my lord. Page 13,
Last paragraph, madam.
last paragraph. Oh.
So this order has been complied with.
According to them,
If
we
you
have
are-
to challenge, madam.
If you're unhappy, you have
Yes.
to challenge this order. That's a
That is-
separate cause of action.
That is submitted. madam.
Affidavit of compliance submitted on behalf of the alleged contemner is taken on record. Paragraph, it appears that the order under contempt has been substantially complied with. Paragraph, in view of the above, the contempt application being CPNs as such is disposed of. Paragraph, there shall however be no redress to costs. Urgent certified website copy.
Madam, you also can, the order is to, it is maybe.
The law permits you, no liberty is
Not
necessary.
permit, but because the contempt matter, we have
Contempt,
to take
you
steps.
are aware that it's very limited.
We are to take steps in accordance with the law. Madam,
Not necessary at all. You can take steps. It's a separate cause of action. Item 9.
And 9 from I am of the petition. But pursuant to your lordship direction, I have served the alleged contemner.
My lord, that's because we
For
are-
compliance,
my lord, we are tied to comply the order. This month, my lord, I'm asking.
1 month.
Yes.
Affidavit of service. Learned counsel for the alleged contemner seeks a month's accommodation to comply with the order under contempt. Paragraph, in view of the above. Let the matter appear under the same heading.
On same day,
On
or 30th.
30th August.
Yes. Get.
Personal appearance.
33. Item 33, personal appearance.
Yes, my lord.
Personal.
Kindly. My lord, Mr. Biswi Dej, may I call, there is no date, time mentioned, my lord. In it. Short password, my lord.
Passover, very good. If Passover rakho na. Mr. They passed over for some time. The petitioner's advocate is coming.
Item 10,
I appear, my lord, for the private respondents in this matter.
And I am for
Private
clarification, my lord.
Yes.
This, my lord, we have challenged an order passed in a proceedings under the West Bengal Premises Land Eviction of Unauthorized Occupants Act. The initial order, my lord, was an entirely unreasoned order. Entire narration of facts, and ultimately held that there was a termination. Due to the termination, I have become an unauthorized occupant. Now, that was my main ground of challenge before the appellate authority, that an unreasoned order is a nullity, and I had cited some judgments, and not only that, even the appellate authority cannot supplement the reasons while exercising jurisdiction of appeal. Lord, the appellate authority has passed an order which is quite a longish order. It has gone into the merits of the matter. It has considered my judgments, which I have cited on the point of this initial order being without jurisdiction, and it cannot be corrected by the appellate authority to that extent. But unfortunately, that point has not been answered. But learned appellate authority has answered on the main merits of the case of my other side. So, my lord, my submission would be that your lordship will either hear out the appeal, and there was an application for stay before the appellate authority. That stay was continuing till the disposal of the appeal. So if your lordship allows that stay order to continue, that they will not only the stay order to the extent that they will not create any third party interest during the hearing of the appeal. That was the limited order.
Position has been taken.
Yes, possession was taken. I came before your lordship. Then your lordship said that the appellate authority must immediately hear out the stay application and the appeal.
And who is appearing for this West Bengal Electronics?
My lord, I am appearing.
They are the main
Lord,
respondent.
I have certain submissions to make, my lord, before your lordship, my lord. If my learned friend has concluded, my lord.
No, I am not. I am saying if it is on the this short issue that since there was a stay order till the disposal of the appeal, that stay order may continue till your.
Let us hear out the matter of merits.
Yes.
My lord, that stay that my learned friend has been, my lord, after that, the appellate authority, my lord, had given hearings. There are his pleadings, my lord, to that effect, that hearing was given.
That is
His
my case.
point of contention is my submissions were not recorded.
No,
After
no.
that,
Well,
Lord,
my lord, let me go into the matter.
I will show your lordship from the records, my lord, because after that, my lord, they had come before your lordship before. Once, my lord, the collector had, my lord, passed a decision, they had come before your lordship in a writ petition. Your lordship had directed the appellate authority to continue with the appeal and dispose it off. After that, my lord, they had gone before the appellate authority. The appellate authority had granted an ad interim stay. Stayed the possession until no third party rights to be created until and unless the appeal is heard out. The appeal was heard out on various dates. After that, a reasoned order was passed, and that stay has been vacated. My lord, today, admittedly, I have been in possession, and there are certain documents, my lord, which they have not annexed because they have breached the principal sublease. Now, that was the only reason why, my lord, they were evicted. They are unauthorized occupants under a special statute. They were evicted because there was breaches, and there are letters, my lord, to which they have admitted to those breaches. Now, my lord, those are not a part of record in this application. They have not annexed those records because there is admission. Based on this admission, my lord, the impugned order was passed. Now, my lord, those are certain facts that I would have to bring on record, and my learned friend is asking for
You have those documents in your possession?
Yes,
in
my
your
lord.
custody?
That was before the
Will not
district
be
magistrate.
necessary, my lord. I have prepared a supplementary affidavit annexing everything.
Have you served copy?
I'm giving
no
a
copy
copy.
has
to my
been
lord.
served.
I'm doing a copy.
To both the state and the private respondents.
Because, my lord, in the event your lordship is allowing, my lord, admission, then, my lord, I'm led by Mr. Dutt, my lord.
My lord, gives us a copy and here is our here, because my lord, my learned friend cannot have three tires on facts.
In the
No, I am not going
meantime,
on
please do
facts.
not create any third party interest.
My lord, I'll put it this way. My lord, I am the owner of the land, my learned friend doesn't dispute. If he wants a stay of his eviction, then he has to put in the loss that I am suffering, which my lord, now Supreme Court has said that you have to compensate him. So compensation, my lord, would be in terms of the present market rate which he deposits. That's the condition of stay which Atmaram has followed throughout, my lord. So let my learned friend take. I will have to also take instruction as to what is the current market rate.
No, then my lord,
Because
kindly.
my learned friend was getting a special rate because he was availing, he had promised the state of West Bengal that he will set up an industry, which he did not do. He sublet it to a pharmaceutical company. So we had to, my lord, take steps.
I am on a much more preliminary point, my lord. If your lordship just sees one order, the order of the first authority.
I think you're serving copy today.
No, that
So-
order is already there with them. That is
Some
no,
opportunity
it's
has to
not
be
with
given.
me.
Let them do this.
HDO,
You have served an advance copy.
but the SDO order is in the writ petition.
And it's quite a voluminous copy. So
Yes,
let's go
because
through
my
it.
defense is there.
This is only a copy of the section 3 application and our objection. But the main order which has been passed by the SDM, that order is already there. Appellate authority is already there. My jurisdictional point which I am trying to take is based on the reading of the first authority's order. Kindly see that order once. If your lordship
With
comes to
respect
the,
to
if
Mr.
your-
Sen, my lord, if my lord, he wants the matter to be heard, then he must give me ample opportunity to bring on record documents which I bring in. May not be by way of an affidavit because I don't have a right. And in any event, these are all matters of
And
record.
if documents are already annexed to the
No,
supplementary.
it's not.
affidavit,
it is now the
The supplementary affidavit.
Then my
So
lord, I
let's
need
go
to
through this and come back.
fix another date, my lord.
But till such time, I must get a
Affidavit
protection.
of
my lord.
service, yes.
I must get a minimum protection till such time, my lord, because otherwise
The order of SDA, my lord, has been passed quite long.
Any action taken shall abide by the result of the
Yes.
writ petition. Affidavit of service and supplementary affidavit submitted on behalf of the petitioner are taken on record. Paragraph, copy of the supplementary affidavit is made over to learned counsels for the respondents in court this day. Paragraph, in view of the same, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on 23rd August. Paragraph, any steps taken by the respondents in respect of the plot in question shall abide by the result of the writ petition.
That's obvious, my lord. In any event, any step taken has to be.
Personal appearance ready?
Appear on behalf of the.
Personal appearance ready? Huh?
33, my lord.
Who is appearing for the petitioner?
I am appearing on.
33?
Yes.
Item 33.
33.
Has not yet come, my lord.
Who has not come?
My lord, that is in the.
Copy to.
Court commissioner.
I'm going to copy the one.
Copy আছে না
কতটা দেখিস? 15-17। আমি এটা অবজেকশন দেবো।
Yes, has the order been complied with? And where is the show cause, Mr. Dey?
My lord, Shokaj and my lord, if your lordship will see.
Please take the microphone.
My lord, if your lordship will see my paper, my lord. Because my lord, original is a. My lord, Shokaj and the report is in the same.
15 decimal দিয়েছি।
In the report, my lord, joint field verification was there, and after that, my lord, it was detected, which is at page 7, my lord, first, second, third, fourth, fifth, sixth, seventh paragraph, my lord, that is. দিচ্ছি দাঁড়াও না। এই নাও।
কত কোনটা অনলাইন কত? কতটা জমি দেখি
দেখো না, এখানে দেখতে পাচ্ছ না?
15 শতক। ভুল দিয়েছি, 22 শতক জমি হবে আমাদের মেজারমেন্ট। 23 শতক না, আমাদের জমি তাহলে আমরা পজিশন নিয়ে নেবো। ঠিক আছে।
So you admit that the land was not acquired?
Yes, my lord.
It was utilized.
Not acquired, my lord. That was detected that up till now that was not acquired. That was utilized.
But it has been utilized.
Yes, my lord.
So what are
That
the
is-
steps that you are planning to take?
Now, my lord, we can take the appropriate steps for acquisition.
My lord,
And-
in respect of my lord, what I find from the report, only here it is shown 15 decimal.
Yes,
15 decimals here. But according to measurement by the surveyor, the land was utilized by 23 decimals. It is much lesser. Kindly see the 23 point dot decimals.
so do you want to come back with an exception to this report?
Yes, right, my lord.
Yes,
Yes, my lord.
Annex your documents, please,
Yes,
with
my
your
lord.
exception. Let him come back.
Yes, my lord. My lord, at the time of,
Hey, this is a contempt. Show
I know,
cause.
my lord.
Where
I
is
know.
the
I am very
evidence?
sorry, my lord, for that.
I will
is
not
my-
accept this. Not today. Come back tomorrow. How can you come be so casual with the court, Mr. Dev? This is a contempt show cause. And your client can be behind bars if a rule is issued.
Lord, I am-
There is two part. First, my lord, that measurement. Second part is
Nothing
compensation.
on
Nothing.
merits.
Nothing
Because,
is-
let it come by way of an
Nothing is
affidavit.
there.
Not today, Guru.
And measurement also but much lesser.
The alleged contemptor should be present tomorrow also. Next matter.
Grateful to your lord.
Item 11.
Item 11, my lord, I beg to appear on behalf of the petitioner. But here, my lord, under the Act 2 of 1948, my lord, the Section 3 notification was being issued. Thereafter, my lord, thereafter, my lord, the 938.
Is appearing, Mr. Dey is appearing.
Yes, Mr. Dey is appearing, my lord. Thereafter, my lord, the 93A proceeding was being converted, but thereafter Section 11 capital A, the time limit, the award was not being published. Admitted position, my lord, I have taken out, my lord, an exception to the report submitted by the, my lord, your lordship is having, my lord, the copy of the exception. If if my lord once looks at page 6, what is the report filed by the, my lord, state authorities? My lord, may I place, my lord, the last but one paragraph? Your lordship will found, my lord, from three lines from the
Gist of the case first.
yes, my lord, the my lord, the Section 3 notification was being issued, my lord, under Act 2 of 1948. Thereafter, my lord, nothing was being done in 2013. My lord, 938 proceeding was being converted. But during the lifetime of, my lord, Act 1, the award could not able to publish, my lord. So 11 capital A, my lord, entire proceeding lapsed. That is their report also, my lord. That's why, my lord, I tried to, my lord, invite your lordship attention to page 6 of the exception.
What is your prayer? Return of the land.
No, my lord, for Lord, in the similar kind of case, Lord, in the same acquisition proceeding, your lordship has passed an order whereby, Lord, direct purchase policy is being adopted, and that order was also being complied with. Lord, I shall show before your lordship that. But the state report, Lord, may I, Lord, take your lordship to that, Lord, kindly takes up my objection, Lord, exception to the report. There, Lord, I have annexed.
Yes.
Page 6 of that, Lord, report. If your lordship kindly, Lord,
Page
take.
6 of the exception.
Yes, exception.
Yes.
Report is being annexed over there, my lord. The last but one paragraph, my lord, the sentence starts with, however, award in the, my lord, has your lordship got it, my lord?
Page 6.
Page 6. My lord, this is the report submitted by the Special Land Acquisition Officer, HON'BLE.
Yes.
Yes, my lord. Last but one paragraph, my lord.
However,
Yes, however, award in the instant LA case could not be declared within the lifetime of Act 1 of 1894, as no approval was received from the department. Notification under Section 4(1) of the Act of 1948 could not be published for acquisition of the land before 31st of March 1997, the date on which the said act was repealed. And thereafter, my lord, from the above, it appears the instant petitioner had no interest or objection in respect of the land. These are the reason for which, I have taken out the exception. They are taking the ground of delay. Now, if your lordship takes up, the exception, page 14 once. The coordinate bench of this honorable court in respect of the same acquisition proceeding, in view of that, the Act 1 period has been over, have already held that yes, the acquisition lapsed. So far as regards the government has to take a decision whether they will take the land on the basis of the market price as direct purchase policy, or they will initiate proceeding, fresh proceeding under 2013 Act. In respect to this, writ petition, final order was passed by my lord. That is annexed, in the writ petition. Page 49. In respect of this writ petition, is disposed of by my lord's order. If your lordship takes up my writ petition, page 49 once. The same writ petition, subsequently, my lord has been pleased to dispose it of, directing the government, since they were agreeable to direct purchase policy, and subsequently, the compliance is at page 51. 51 in respect of the other land loser, in respect of same acquisition proceeding. Ultimately, they have given the direct purchase policy benefit. And
Yes.
So my lord, now Mr. Dey has to take a my lord, decision whether my lord,
Yes, my lord, direct purchase policy has, because whether there is an estimate was there, as per my report, my lord, there was a estimate.
So you're agreeing to
Complete.
direct purchase?
Yes, my lord,
policy.
as
So let me be
estimate
more-
is there, my lord, so direct purchase, there is no any problem arose. সেটা কি তোমার নাকি পরেরটা 13টা কি তোমার আমাকে একটা কপি দিতে বলো তো শোভনকে
Heard learned counsels for the parties. It is contended on behalf of the petitioners that no, it is not in dispute
এটা তো
that the land of the petitioners
না এটা 25টা
was requisitioned under section 3 of the West Bengal
13টা,
land
13
within bracket requisition and acquisition,
13টা
bracket
পিটিশনে
close
কপিটা
Act,
সূত্র দেবে আমার
1948, and possession was taken over. These are all undisputed facts. isn't it?
undisputed.
Possession was taken over on 13th February 1987 for construction of a road, cholche na, from Jangipara to Borhal, BORHAL, in the district of Hooghly. Vide LA case number
বলেনি যে টাকা দিয়ে দিতে, ঠিক আছে? তাহলে আবার এটা
1-4/86-87.
তো টাকাই তো হয়ে গেছে, এবার তো ওরা কমপ্লিট করে দেবে 4 মাসে।
Award stop. Since award could not be declared during the lifetime of the Act of 1948, notice was issued to the landowners under section 9 within bracket 3 capital A bracket closed of the Land Acquisition Act 1894 on 26 March 2013. Final estimate was sent to the Land and Land Reforms Department and fund to the tune of rupees 2,43,22,758 was placed before the was placed from the executive engineer placed from the executive engineer, Highway Division, Roman 1. Vide memo dated 14th December 2012. Stop. Award in the LA case could not be declared within the lifetime of the Act of 1894, since no approval was received from the department. Paragraph in view of the above, learned counsel for the state respondents submits that the state is agreeable for direct purchase of the land by the government You are agreeing to such proposal?
Yes, agree to?
Yes.
Stop. The petitioners also agree to such proposal of the government. Paragraph. Accordingly, the writ petition is disposed of.
Lord, your lordship, kindly give one line observation so far as regards Lord, Mr. Dey is there, Lord. The Lord, in the other matter, Lord, they have taken the point in the direct purchase policy, the name of the committee's members.
This is the same acquisition case.
No.
The same LA case.
No. In one of the matter, Lord, before in the contempt jurisdiction, your lordship has faced, Lord, the stand taken by the state that in the writ petition, all the committee members who are there, Lord, in the direct purchase policy, they were not made parties.
No, my lord,
Your
I
lordship-
never take that
No.
point. my
Mr.
lord.
Dey was
I
not
take
there.
that point.
But learned
that
advocate,
DM is the, my lord, DM is the, my lord, the chairman of that committee. DM and my lord, principal secretary of the finance will be a party of the person. I
So
submit.
have you
before your
made them
lordship.
parties?
But here district magistrate and land acquisition collector are the same. Is respondent number 2.
But the money will be paid by the executive engineer
So let one
within
and
certain
both
time.
be
Yes.
responsible.
Yes,
Yes,
that
madam.
that
One
my
is
lord,
the second, yes, 1 and 2 both.
I'm extremely good.
And the earlier writ petition at page 49 is with regard to the same acquisition case.
Same acquisition case. Same acquisition case, different land loser.
Different land.
Land
user.
loser.
Interesting.
Considering the category, after paragraph. Learned counsel for the petitioners takes this court to an order passed by this court on November 30, 2021 in WPA 16856 of 2014, which was filed in connection with the same land acquisition matter as in the present writ petition by another land loser. In the said matter 2 TWO, comma, the state agreed for direct purchase of the plot in question and the order of this court directing initiation of process of direct purchase within a stipulated time frame and conclusion of the same within a stipulated time frame. And conclusion of the same within a stipulated time frame was complied with by the state.
In a contempt, my lord.
Yes.
There also contempt was made. Thereafter, this was contempt. Not your lordship will get page 51, the contempt number also. CPN 446 of 2022.
Upon filing of a contempt proceeding being CPAN 446 of 2022. Paragraph. Upon consideration of the submission made on behalf of the parties and material on record, comma, the writ petition is disposed of, directing the first and second respondents.
And my lord, fifth respondent.
3 of them.
Executive engineer is the my lord. Money
So
will be
all
paid.
3 of them.
Yes, my lord. All 3 of
First,
them, my lord.
second and fifth respondents.
Yes, my lord.
To initiate the process of direct purchase of the plot in question at the earliest and take necessary steps for conclusion of the same within 3 months.
Yes. Within 4 months.
4 months.
Yes, my lord.
Within 4
Otherwise,
months from the date of communication of this order.
this case, my lord, money has already.
Comma, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, comma, in accordance with law.
I'm extremely good.
Disposed of, which actually. Yes.
The next 2 matters are similar, 12 and 13.
Some of the state.
Same as this matter.
Yes, same.
Yes,
The same order can be
Same.
passed. They are
12
different
and
land users.
Yes, different lands. But in respect of same
The
acquisition.
same acquisition.
Exactly, not
Same
on
order.
same of price.
12 and 13.
12 and 13 and affidavits. I'm extremely.
13.
My lord, I am appealing for the petitioner. My lord.
13, same order.
Yes.
14.
14, I am appealing for the petitioner. My lord. I am filing this affidavit of service and supplementary affidavit. My lord, the earlier order, my lord, I am
Supplementary affidavit.
supplementary.
Have you served?
Yes. My lord, I am showing this, my lord, identical order may be passed, my lord.
What is the matter about?
Yes, my lord. The petitioner is, my lord, running the brick field, carrying the business brick field. And since the earlier submission was, my lord, the petitioner lifting the clay from the private land, since there is no privity contract between the state authority and the owners. So the exemptions of royalty was prayed before your lordship. And after submissions of the both sides, my learned senior friend stated that the ADM and DLLR is the appropriate authority to decide, and he may be added party and make fresh representation, and the such representation shall be considered.
Consider.
Well, I am saying the identical order.
Please show the said order to Mr. Devans.
Yes.
এটা তো ডিস্ট্রিক্ট ল্যান্ড অ্যান্ড ল্যান্ড রিফর্মস অফিসার পাঠিয়ে আছে my lord here district land and land reforms officer
ADM and
the
DLR.
proceeding, so no need of
ADM and DLLR of Purbo Midnapur.
district land and land reforms officer is also ADM, so no need of any.
So he'll do.
Yes, my lord, he can do this.
The second respondent.
Yes, my lord. The third respondent, district magistrate is the second respondent.
District land and land. Yes.
And now it allows.
He is the ADM.
Yes, my lord.
Where is the notice demanding royalty?
Yes, my lord. At page 41. And 41A. Claim royalty.
Two separate notices.
Yes, my lord.
Two separate notices.
Yes, sir. The consecutive same note. Last notice.
It's the same notice.
Yes, my lord. Last notice is 12 December 22, page 41A.
Yes. Affidavit of service and supplementary affidavit submitted on behalf of the petitioner are taken on record. Paragraph. It is contended on behalf of the petitioner that he is running a business in the name and style of inverted comma new Ma MAA Bogulamukhi Brick Industries and Company inverted comma closed in his
Brand
royalty
Shri
land.
Brick, my lord.
Yes.
Brand Shri Brick within bracket.
Inverted comma close पर comma din brand 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 hyphen Sri Brick SREE Sri Brick to inverted comma राखूं BRICK SREE Sri Brick in his Rayati land and has no privity of contract with the respondents, despite which the respondents have demanded royalty and cess from the petitioner for running the brick field by letters issued on 15th June 2022 and 12th December 2022. Paragraph. Learned counsel for the petitioner submits that since there is no privity of contract between the parties, comma, the respondents are not entitled to claim royalty and cess in respect of the plot in question, which is the Rayati land of the petitioner. You want to file a representation, submit a representation.
Yes, my lord. I submit.
The petitioner seeks to submit a comprehensive representation in this regard before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, comma, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the third respondent within a fortnight. Within a fortnight from date. Stop. The third respondent is directed to consider and dispose of the representation 6 weeks. Within
Yes, ma'am.
6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of with action. Next. Tim.
Same.
My lord, I am appearing for the state, my lord.
Same order will be
Paid by
passed.
Mr. Shantanu Mitra, my lord.
And
My
here,
lord, he made application, my lord, praying for time for deposition of the royalty, my lord.
same was, but I challenge only the royalty.
But you have prayed for time.
Connection has been made, my lord.
With all the application also, this is the wait for time due to Amphan. And Malo, here is the challenges, Malo, on the same cause of action, for exemptions of royalty on the ground of there is no privity contract between the state and the owners. Cause of action is same. And Malo, see is at page 29.
Of the dues of royalty. Hence, you are asked to show the documents of payment of dues, but till now, my lord, no documents, my lord, had been shown by the.
Come to page 30, it's an application for exemption.
Yes, my lord. Yes, my lord.
So let this application be considered.
No, on the same identity, I shall make fresh representation.
Let him make a fresh report.
My lord, my lord, my lord.
And here, my lord, that, since the ADM and DLR was not made party, liberty may be given to add it as a respondent number 5.
He is a party. Paragraph 3, the third respondent will deal with it. SDL and LR. He is the
Subdivision, respondent number 3.
Same order হবে ব্রিক ফিল্ডের নামটা বলছি ভুলে গেছি মা বহুলামুখী ব্রিক ইন্ডাস্ট্রিজ এন্ড কোম্পানি ইনভার্টেড কমা ব্র্যান্ড ড্যাশ সাথী ব্রিক SATHI সাথী ব্রিকটা ইনভার্টেড কমা ব্রিক সাথী ব্রিক ইনভার্টেড কমা ব্রেভিটি অফ কন্ট্রাক্ট যেখানে বললাম তারপরে একটা প্যারাগ্রাফ অ্যাড হবে এটাতে এই যেখানে রিপ্রেজেন্টেশন দিতে চাইলো না 6 টু ফাইলের রিপ্রেজেন্টেশন যেখানে বলেছে তার আগে একটা প্যারাগ্রাফ অ্যাড In reply to a notice issued by the respondents for payment of royalty, the petitioner sought a month's time as appears from a notice issued by the authority on 19th February 2020. Stop. Taporé, the petitioner seeks to submit a representation within 6 weeks.
Yes, my lord. My lord, enclosing all the documents, representation may be made, my lord.
He'll be given an opportunity.
My lord, my lord, my lord.
Should the affidavit service. Next.
I'm getting- 16.
16, my lord, I beg to appear on.
I appear on behalf of the state, led by answer.
One of the one Narendranath Kaur was the recorded right, arrest recorded right. His legal heirs transferred 27 decimal of land to one Ashok Kumar Mondal, who got his name recorded in LR record of rights. Subsequently, Ashok Kumar Mondal transferred the property to petitioner number 2 and 3 by through a registered deed of sale, and they also got their name recorded. Subsequently, petitioner number 2 and 3 transferred certain portion out of their portion to the petitioner number 1. Total quantum of the land is 27 decimal. My lord. Last page, my lord, turns to the nature of acquisition. Page 75. Without initiating any proceeding, any notice, any sort of.
Page 25.
75, my lord, the last page. Has affixed a board. The entire plot has been acquisition. This is the nature of acquisition.
This plot covers both all the plots of the petition, all the three petitions.
611, plot number 61, my lord, kindly turns to page 74. Name of the petitioner number 1 appears. Plot number 611. His name has been recorded in respect of 13 decimal. My lord, then turns to page 75. Plot number is same. This is the nature of acquisition, my lord.
Yes.
Not, there were big wrath cases, some big wrath cases were initiated and that were disposed of on contest. Thereafter, I am filing the report given by the SDL or BLR. So this is a report, my lord.
What was disposed of on contest? Have you served a copy of the report to the petitioner?
Report.
Please serve a copy to the petitioner.
এটা একটা পিটিশন দিয়ে দিবে আর একটা নেই তো
The report says it is vested under the Estates Acquisition Act. So in that event, this court will not probably have jurisdiction.
may I go through it and take an
Please go through
exception
this
to
and
that?
come back. Yes.
Because my contention, I was allowed to retain certain quantum of land. Subsequently, my lord, the legal heirs to the riot transferred the land. Our
So
name was recorded. A vested land cannot be recorded in the record of rights.
initially under the Estates Acquisition Act.
Exactly, my lord, that I have
This
stated.
court will
Subsequently,
not
I was allowed to retain.
Yes, in that
I'll
case,
substantiate with documents.
that case also, this court will not have jurisdiction to deal with the matter.
No, my lord, kindly allow me to go through the report that have been filed. And liberty be given to take exception if
Because
any.
this percolates from Estates Acquisition Act.
Kindly allow me
This
to
is
go
a specified act. Please consider this issue also.
through. Certainly, my lord.
Report submitted on behalf of the state respondents is taken on record. Paragraph copy of the report is made over to learned counsel for the petitioners seeks to use an exception to the said report. Paragraph, let the matter appear under the same heading on 25th August.
25th August.
August.
Not affidavit of service be kept in the record.
শুরুতে affidavit of service.
এখানে receive করলাম।
17.
My lord, I am being led by Mr. TM Siddiqui. He is on legs before the honorable division bench.
But no difficulty, my lord. After a month, we have been, my lord, supplied a copy of a report, my lord, on Saturday in the afternoon. My lord, we need to, my lord, consult the report and, my lord, filed an exception to that report. If my lord kindly grants us a fortnight's time, my lord, they were supposed to give us the report, my lord, beforehand. Anyway, my lord, that has come on
That's
Saturday.
also beforehand.
Truly.
It has not come to court till now. Where is your report?
Uh,
Submit the report at least. You're not ready with it.
I do actually, I'm not aware of this, the progress of this matter. So I'll let my senior know. And
Sir, please be aware of little more facts than only pass over an adjournment. That will
Yes.
help you,
yes,
not
my
the court.
yes, my lord.
If my lord wants to have a look at the report, my lord, I can, my lord.
Not necessary. Let them file
Great.
it.
Great.
A learned counsel for the state respondents seeks accommodation. Paragraph, learned counsel for the petitioners seeks to use an exception to the report, comma, copy of which has been made over to learned counsel. The report has not been submitted as yet. Paragraph, let the matter appear under the same heading on 25th August.
25th August. Right. And my lord, may it's retain its position, my lord.
Yes,
May the matter retain its position.
I hope it will read.
Great.
It's a 23 matter, so.
Great. Great. Great.
18. 18.
But I am for the petitioner. What happened, my lord? The petitioner's premises is adjacent to the PWD's land.
Take the microphone, please.
Petitioner's premises is adjacent to the my lord, PWD's land, and therefore, my lord, even if it is the land belongs to PWD's, my lord, it is used by the petitioner as ingress and egress. But my lord, it is obstructed by way of constructing park structure, and therefore, my lord.
Affidavit of service.
Not kindly see this. Affidavit of service.
The private respondent has been served?
Yes, yes. And my lord, the petitioner, my lord, file a representation before the executive engineer, my lord, PWD, Tomluk, my lord, division, my lord, that is annexure P4, page 22.
Mr. Day, let this be considered. Yes, madam. Affidavit of service. None appears for the private respondent despite service. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of PWD land adjoining his property, comma, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation before the concerned authority in this regard on. Where is the date of your representation? No date.
My lord.
Date of your representation? 16 January.
14th January 2023.
Where do you find the date?
My lord.
Oh, here, yes. On
at the
14th
bottom of
January
the-
2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the fourth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is, the assistant engineer will consider.
My lord.
Yes, ma'am.
The assistant engineer will consider. In view of the above, the writ petition is disposed of directly.
Just to executive engineer.
Considered by the assistant engineer. To consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law.
Assistant engineer is 4.
Four is being directed. Disposed of which?
Within
3 months.
19.
Because proceeding has to be initiated. Yes. Please take the microphone, sir. Please take the microphone. Microphone.
Now, my lord, challenging the order of the district land and land reforms officers, Bakura, regarding annexure P8, my lord, page 53. Herein, my lord, your lordship has directed to the district land reforms officers to, my lord, consider my representations, and the representation was considered. Now, my lord, regarding the renewal of my license, which has been, my lord, pending before them, has not been decided in accordance with law. Actually, the fact of this case is this, that the road for transportation of sand from the riverbed has been washed away due to the force majeure, due to the flood. The time limit to be added with the, the limitation time, but they had not been added it. And now, my lord, I have also filed the application in due time, but due to the ignorance of the law, my lord, I cannot, my lord, file the D form within time. But within 15 days, I have filed the D form also. But they had not been considered this thing. I have made the representation also. Later on, they say that there is the due for government dues. I have paid all the government dues. I also paid to them for giving the amount. They assess it. I have no objections for giving the amount. Let they renew my license, my lord. The license was been actually granted initially in the year that is, I have heard the petition and gone through the case record. Honorable, I find that the lease deed of the petitioner was registered on 11/9/2019, 2009. So that the date of expiry of the said lease was 10/9/2014. But within a short period of time, my lord, I have already filed, my lord. I have categorically stated in my petition, my lord, that is page 6 of my petition, para 11, my lord.
You have in fact challenged this order passed by the district land and land reforms officer, isn't it?
Yes, my lord. Yes, my lord.
So this is an appealable order.
No, my lord. The considerations which they have been made without extending, my lord, renewal of my license, my lord, is illegal, my lord.
Yes, so in that case, you can prefer an appeal against this order. Rule 51 of the concession rules, 2016 rules.
So, my lord, your lordship, my lord, the limitation time to be considered. My lord.
Yes, I will do that.
Yes, ma'am.
Limitation will not be taken into account. It will be disposed of on merits.
Yes.
Mr. Protocol, that was your submission.
Yes, ma'am.
Affidavit of service. The order passed by the district land and land reforms officer, Bankura, is under challenge in the writ petition. Paragraph. The said order is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Concession Rules, 2016. Paragraph. In view of the above, the writ petition is dismissed as not maintainable. Paragraph. However, the petitioner is at liberty to approach the appropriate appellate forum for redressal of his grievance. Paragraph. In the event the petitioner approaches the appellate forum, in the event the petitioner files the statutory appeal within 15 days, within 15 days from date, comma, the appellate forum shall dispose of the appeal on merits without dismissing the same on the ground of limitation. Paragraph, there shall however be no orders to cause as in certified website. Next.
Lord, I beg to appear for the petitioner.
Have you served?
Well, I have served.
Well, I am appearing on behalf of the cantonment.
So there is an allegation and our
The
allegation.
private party also has been made party.
Yes, well, I have served.
Yes.
Private party is there. He is constructing the unauthorized construction without taking any.
Serve the private.
My lord. This is my lord, the area within the area of cantonment, my lord. Barakpur cantonment. Page 55 is my
Please wait.
my
Please
lord,
give me a
my
minute.
Page number 12 of the affidavit of service. Service upon the private respondent. Total. No, private service to কত নম্বরে আছে? All item has been confirmed, my lord, delivery.
One, two, two.
Yes.
Well, the private parties herein, the area is within the area of cantonment, Barakpur cantonment area. My lord, the private parties, we are residents of my lord 21 and private parties are 20. Now the private parties are making the unauthorized construction without taking any permission from the cantonment board. In view of my lord section, the provision of 234.
How are you concerned?
My lord, I am the next neighbor.
So?
My lord, it caused my lord blockage the drain, my lord, etc. Other my lord, travel is also causing. And 234 of the Cantonment Act, my lord, the permission is necessary. Please have a look.
Let me I raise a preliminary objection. This is an issue not only in this case, my lord, almost many cases relating to cantonment, my lord. My lord, whether this will fall under group 5 of the determination or not, because although it is not specifically defined as a municipality, section 10 says for the purpose of receiving grant and implementing central government, it is to be deemed municipality. So I am facing this problem. In fact, in another case, my lord Justice Devanshu Achuk had released the matter on the same ground. This is not this, my lord. My lord.
Difficulty is that this is not within the panchayat or municipality.
No, this, my lord, section 10, your lordship can see.
If your lordship hold and my lord release, I have no objection, but it is not, my lord, within.
Section 10.
Affidavit of service. In view of section 10 within bracket 2 of the Cantonments Act 2006, the subject matter of the petition can be classified under group 5 of the classification list. Paragraph, the matter is released due to lack of determination.
Grateful. The affidavit service be kept on record, ma'am.
Boy.
21.
21, my lord, I am appearing for the petitioners, my lord. May I file the affidavit of service? My lord, petitioners are the owners of a portions of a.
Development Authority.
Yes.
I am for respondent number 5.
My lord, petitioners are the
Respondent
owners.
number 5,
5, my lord.
National Health.
national.
My lord, may I tell your lordship the
And who's appearing for the state?
Ma'am.
Mr. Watson.
Lord, petitioners are the owners of portions of a particular plot adjacent to National Highway 19. My lord, the project of widening of National Highway 19 took place, my lord, when we were served with notices for removal of unauthorized occupants. My lord, we challenged the acquisition proceedings. My lord, it came up to this Honorable High Court. The acquisition proceeding has been held as lapsed. And the notice, particularly in that order, my lord, has been the authorities were restrained to proceed further with the said notice. Subsequently, they have issued a notice for removal of unauthorized occupants from the plot number which belongs to the highway. Now, my lord, we raised an objection. We said that which portion is our unauthorized, whatever, you just demarcate and do that. They agreed to the proposal, and thereafter, my lord, they undertook a measurement. My lord, may I come? My lord, kindly comes to page 90. This was the subsequent notice where plot number 305 is mentioned. Now, my lord, kindly comes to page 101 onwards. Page 101, my lord, this is the notice of the, this is the reply to our objection by the highway authorities, where, my lord, they says, my lord, the second paragraph I am reading, the last paragraph, therefore, you are with respect to your representation objection letter dated such and such, hereby invited to the office of the highway administration at about 12 noon, along with lawful documents or any query or objection against the demarcation of plot number 305, which is government land, belongs to highway, failing which lawful measures will be taken for demarcation of IBID plot 305 of Alisha, Purva Bardhaman, and further proceedings as per law. Now, it kindly comes to page 102.
Yes.
This is a notice for rescheduling of the date of hearing. Then, my lord, page 103, my lord, this is the minutes of the hearing. Page 103. Project Director PIU Durgapur welcomed the disputed landowners of plot number 82. The objection and its resolution thereof were discussed at length and following were decided. Project Director informed that a joint site measurement is being scheduled through the LA Department, Government of West Bengal, for proper demarcation of NH land in plot number 305, Moja Alisha. Point number 2, the disputed co-owners of plot number 82 agreed to the proposal and informed that an Amin appointed by them will also remain present during the joint measurement for demarcation of national highway land in plot number 305. Project Director agreed to the proposal and stressed upon early resolution of the matter so that the work could be progressed at site. The date of joint site measurement with the department was tentatively fixed on 9/12/2022 with the consent of all the attendees. Thereafter, my lord, the joint measurement was held.
Annexure P5.
Page 105.
Yes.
This is the notice which they are again serving upon us without serving us the copy of the map. We insisted only to give us a drawn to scale map so that we can know how much, how much is to be demolished or rectified by us.
This measurement was done in your presence?
Yes. We have no dispute with that. They are not supplying the map. Only this much relief we are asking for. Now, they says, my lord, during the demarcation, my lord, page 105, Again, my lord, this kind of, my lord, vague notice. During the demarcation, it has been found that some portion of NHAI land has been encroached by you. Hence, notice is being served under the control of the National Highways Act to clear all encumbrances within 7 days, failing which eviction drive will be undertaken with the support of district administration. My lord, we immediately made another representation where, my lord, kindly comes to the last portion, page 107. The penultimate paragraph in the above premises. Your lordship got it in page 107, the second last paragraph.
Yes.
In the above premises, your immediate notice to remove the encroachment of some portion of NHAI land without actually serving the proper map of such demarcation upon me, us indicating the alleged encroachment is inherently vague, obscure and incomprehensible, kindly cause to serve a proper map of demarcation duly authenticated by all the participants of the above joint measurement, so that follow-up actions may be thought of being undertaken for the required purpose. Be it further clarified, in the absence of such duly authenticated map of demarcation, the undersigned is handicapped in this matter, and for which your authority may also find it inconvenient. This is a very innocuous prayer, my lord. Nothing more, nothing less. So kindly do the needful so that the matter may be resolved once and for all. In the meantime, your authority is further requested not to take any coercive steps. And in my petition, this is my prayer only.
Yes.
We have no role to play, man. But the National Highway is the authority, man.
No, National Highway Authority, 105 mile, page P, annexure P5 mile. On the basis of that, it is found, my lord, it has been encroached, some portion has been encroached by the petitioner. It is found.
Have you given the copy of the map?
No, it has been sent to the LA collector, my lord. If it is directed to the supply, my lord, it has been after completion of the joint survey in evidence of the both parties. Or my lord, direction to file a short affidavit along with the submit, my lord. I will get instruction to file a short affidavit along with the relevant documents. And already been sent to the LA collector, my lord.
A copy of the report along with the map ought to have been served on the
Yes, it is
petitioner
true.
also.
They have prayed to consider the representation. Only, my lord.
Be considered and the map be
Map
supplied.
is
That's
applied.
all.
Yes,
Yes.
the
There's no
map
need to
actually,
waste further time.
it has been sent actually, my lord, the LA collector, land acquisition officer, my lord. Direction also,
And the
direction,
collector was
both,
a
my lord,
party,
direction.
the petitioners were also parties to the demarcation.
Yes, yes.
So they need to know which portion has
Yeah,
been
it is true, my lord.
encroached upon. isn't it?
Obviously, my lord. Direction is given to both the National Highway and also the LA collector, my lord. Then it will be better, my lord.
It is your notice. So you have to supply a copy.
Actually, it has been sent to the LA collector.
You have sent a copy.
Copy is there or not, actually, my lord.
That is
Both parties direction, my lord. Either they will consult, my lord, with the LA collector. If it is under the custody of the NHA, they will supply. No
What
problem.
happens? LA collector will ask you, you will ask the LA collector, and finally no one will give the copy. So it is your responsibility. If you do not have a copy, get it from the LA collector and give it to the petitioner. It should be your
The
responsibility.
joint measurement is done at the instance of the highway authority.
Absolutely, absolutely.
It has been done in pages of
Affidavit of service.
Yes,
petitioner.
yes. And my lord, without the supply of the copy of the map, my lord, let them not take any
My
courses.
report may be given. Copy of the report may be given. Survey report, my lord.
Along with the map.
Map, my lord. It is the under the map actually controlled by the LA collector. This is the state government.
No, if the joint
report, the map is part of the report.
It
You
is
cannot
by
prepare
following the
it
map. By
without the
following the
map.
map. Yes, it is
You
true.
cannot prepare a report without the map.
It is true.
Isn't it?
Yes, my lord.
So when you
At the time
submit
of
a
survey.
report,
At the time of survey. Yes,
when you give the report, the map should be annexed to it.
my lord.
and let no coercive steps be taken without supplying the copy of the map.
It is submitted on behalf of the petitioners that
স্লিপটা দাও, ফাল্গুনে তো সব নিয়ে নিয়েছে।
আর তোমার নাম লাগে না, মানে স্টেজের নাম লাগে।
pursuant to a notice issued by the National Highways Authority of India on 16th November 2022 under section 28 within bracket 2 of the Control of National Highways within bracket Land and Traffic bracket closed Act 2002, comma. The petitioners
क्षमा मुखर्जी তখন ছিল 2012 সালে সেটা অ্যাপিল করেছিলাম সেই সময় ব্রেকথ্রুসে ক্ষমা মুখর্জি গেছে ক্ষমা মুখর্জি আমার কেন
were called for a hearing by the authority on 2nd December 2022 and were directed to submit documents or objection, comma, if any, comma, against demarcation of the plot in question being plot number 305 in Alisha Moja, which, comma, according to the authority, comma, belonged to the government. Upon hearing the petitioners and other relevant authorities, comma,
I am appearing on behalf of the Burdwan Development Authority.
Yes.
I am appearing on behalf of Burdwan Development Authority.
আগে একটা বলছি আগে যেটা হিয়ারিং হয়েছে সেটা বলছি যেটা হিয়ারিং হয়েছে ওইটা বলছি
it was unanimously resolved that a joint site measurement would be held for proper demarcation of the national highways land. Stop. Such demarcation was made in presence of the petitioners, following which a notice for removal of encroachment was served upon the petitioners by the National Highways Authority on 16 January 2023.
Well, the meeting was held on 5th of December. It was rescheduled.
No, then the demarcation took place.
Yes, your lordship has ordered, my lord, the meeting was held on 2nd. First, it was fixed on 2nd. Thereafter, rescheduled on 5th.
যা হয়েছে যে রিপোর্ট সার্ভে তো হয়ে যাবে
January 2002.
Page 102.
নোটিস ইস্যু করছে ইস্যু করছে কারণ ওটা বলার তো ক্ষেত্রে কি আছে
Which was rescheduled on add করুন, which was rescheduled on 5th December 2022. 5th, second ever rescheduled on 5th December 2022. ঠিক আছে, ঠিক আছে। Last কি বললাম?
ওটা টাইম নেব সে শ্রীকান্ত মামলা পোস্ট হয়তো পোস্টটা ব্যাংক immediately towards 2 weeks time
In reply, stop. Open add করুন ওর সাথে without serving copy of the It's a sketch map. Sketch map,
Drawn to scale sketch map.
yes.
Drawn to
Sketch
scale.
map of demarcation to the petitioners. Stop. The petitioners, comma, by a representation submitted on. What is the date of your representation? 20th January 2023, comma, requested the authority to make over a copy of the duly authenticated map of demarcation indicating the allegedly encroached portion. Paragraph. Who should be directed? The third respondent.
My lord, the third respondent is authority. Durgapur.
Upon consideration of the submission made on behalf of the parties, comma, this court is inclined to hold that the third respondent be directed to deal with the representation submitted by the petitioners dated such and such and make over a copy of the authenticated sketch map of demarcation to the petitioners within 1 month. Within 1 month from the date of communication of this order. Stop. Pending disposal of the representation, no coercive steps.
Only this much.
No, my lord. In the meantime, my lord, kindly consider this aspect, my lord. If he is entitled, any person, my lord, then he will get the legitimate compensation.
So that is a different thing.
What's this? This is the
You have to hand
my lord,
over a copy, sir. Before that, no coercive steps.
my lord.
Till disposal of the representation.
Let them hand over tomorrow.
Official work, my lord, they will get the copy. They have to issue the notice. But in the meantime, my lord, the what's
Issue the
not
notice of what?
What is over?
we have to serve the notice, my lord, to appear.
Yes.
Then, my lord, it is the actually, my lord, the
And in the
official
meantime,
work.
you take position and you continue your.
No, if he is entitled, he will get the compensation in future.
No, this is the case.
That is the law. That is the law, my lord.
Compensation.
Actually, my lord, the public interest. Kindly consider the
You have-
public interest.
this
If
is
the what's is
important.
not a case of
incompleted, so many places it is stopped, my lord. This is the very great problem, my lord.
Dispose of the representation immediately.
Yes, let them do it
No,
tomorrow.
If he is entitled, my scheme, man or
Only the
others,
man,
if
only
he is
the man.
entitled,
Of the representation in 2 weeks.
2 weeks for now.
2 weeks without my lord, 2 weeks, my lord, no stay, my no,
No.
other 2 weeks, my lord. In the meantime, 2 weeks, my lord, not stay, not the
Dispose
entitled.
of the representation as early as possible. That will
Yes,
help you.
it is true. Is it?
Paragraph pending disposal of the representation. Pending disposal of the representation, comma,
Then 1 month, my
coercive steps be taken against the petitioners in respect of the plot in question.
Grateful.
Then it is 1 month, my lord.
1 month করলাম কি? Within 1 month.
Grateful, my lord.
Disposed of. Next.
You are right.
22.
May I please
My
the
lord,
lordship?
I think, my lord, matter can be disposed of within a minute.
22.
24.
Let me take the. Who is the petitioner?
My lord, I am for the petitioner, my lord.
Yes, what's the matter?
My lord, this pertains to the acquisition of land pertaining to the adjoining areas of Habra Hospital, my lord. My lord, what has happened? Initially, a show cause notice under 3 was served upon some of the certain petitioners. The petitioners are amongst the other persons who are residing and also the owners of that plot of land, my lord. Now, my lord, one of the petitioners in this present round of litigation, there are altogether 7 petitioners. Out of the 7 petitioners, initially the show cause notice was challenged before this honorable court. Subsequently, a order was passed directing to dispose of my representation by allowing me to file a reply to the show cause. A reply was filed. The other petitioners concerned similarly
filed representations before the authority concerned saying that I am out of time. The benefit of the order passed in favor of the petition number 1 should also be benefited, should also be forwarded to the other petitioners. That has not been placed, my lord. Thereafter, a proceeding under order of eviction passed under section 4. My lord, that will appear at page 89, my lord.
A report was called for from the.
My lord, may I submit? My lord can dispose of within a minute. Only thing. Page 89, this is the order of the subdivisional magistrate under section invoking under section 4.1 of 1962 Act. My lord, note that there are 3 acts. One of them, 1962 Act, that is
Yes.
unauthorized West Bengal public land eviction,
Unauthorized
unauthorized occupation and
my lord.
decision. So, my lord, what has happened? Order was passed. Rightly, wrongly, it was passed against them. They preferred an appeal under section 7. Appeal is pending. That is their case. So, my lord, till the disposal of the appeal, the stay should be allowed to be remain. That is the thing, my lord. Till, no. That he did not challenge this order. 89, he did not challenge. Kindly see the prayer.
My lord,
Kindly
it is
come.
my
No,
case, my lord.
my lord.
Kindly allow me to place my
No,
case.
my lord. Kindly see the
My lord,
prayer.
it's not
My
that
lord,
the case is supposed, the state
kindly
is supposed to
see the
defend the
prayer.
case, my lord.
Whether he has challenged that a subdivisional magistrate order under section
My
4.1.
lord,
No.
kindly come to page 103
What
for
is
once,
this
my lord.
challenge? Section appeal is pending. By this time, you have issued the order of execution by dated 17 March
That is my
27,
case, my lord.
22. That is his
precise,
case.
that is precisely my case.
Eh,
The
That
pendency
is
of
why
the
I am
appeal,
making submission.
there is,
Spending admitted.
Yes.
my lord, I don't know. Kindly come to page
I don't know.
103. Kindly see the observation made under page 103, my lord, for once. My lord, second paragraph, it further appears that the said order dated 10th of November 2022
Whether
was
he
challenged before
challenged-
the appellate authority before the district magistrate in appeal case number 3 of 2022 and others which were dismissed on merit on 28th of November 2022. Now my learned friend is saying that the appeal have not been disposed of. The appeal is pending. My lord, my case was, I have preferred 7 different appeals. All have been numbered at appeal case number 3. I don't know how come that can be possible. My lord, all a separate cause of action. All the matters have been taken up altogether. Thereafter, or no order was passed.
So it was dismissed.
I don't know, my lord. Kindly
That
come.
is the order.
My lord, if the order have been dismissed, my lord,
And
if
my
my
lord,
appeal
see
have been
there-
disposed
see there-
of,
see
then
there,
there should
Avarle.
be an order, my lord. My lord, there should have been an order. My lord, kindly come to the very next page, 105. My lord, this order, my lord, this order was
105.
103, my lord. 103 was communicated to me on 28th of March 2023. That will appear at page 102. Now, my lord, upon knowing, I immediately made representation 30th of March saying, I don't know what was the fate of the appeal preferred by me. Even if it has been disposed of, kindly provide me a certified copy of the order. Now, my lord, on 30th of March in 104, 103, they are alleging that the appeal have been disposed of on 28th of November 2022. My lord, now kindly come to, my lord, on page 91. This is the notice of the appeal, my lord.
91.
Page 91. These are the notices which have been served upon the petitioners on 9th of December 2022. The second last paragraph, it says, so both the parties are directed to attend the hearing himself, herself, or through any authorized representative in support of the claim, if any, on 22nd of November 2022 at 3 p.m. My lord,
22nd of December.
22nd of December. Hearing was called for on 22nd of December for hearing out my appeal. Now, in the order, execution order, it reflects that the appeal have been disposed of waiving in November, my lord. This is their case, my lord.
My lord, only thing, my lord, kindly see page 106, 107, 108, 109. Kindly see what is this contention. Appeal is pending. So, my lord, so do not execute that order.
I can place
my
my
lord, may I-
content of the 106, my lord.
Page 103.
103, my lord, kindly come. 103, my lord, this is the, my lord, this is the order of execution. That is, my lord, kindly come to page 89.
Please come to the second paragraph of
My lord,
103.
page 89, this is the order of the subdivisional mandate invoking under section 4.1 of 1962 Act. Kindly see, this order was not challenged. I am showing his.
This order was challenged in appeal.
Appeal is pending.
Where is appeal? Come to page 103,
My
second
lord,
paragraph.
no, my lord, 103. My lord, I am showing 103.
Please read
This
the
is
second paragraph.
27th, my lord, kindly see the date, 27th March 2020. And this is 10/11/2022.
22nd March
2023.
2023. And it is recorded that.
103.
Mr. Sengupta, please come to the second paragraph. The order dated
appears.
10th November 2022 was challenged and appeal has been dismissed.
Before the appellate of before the district magistrate and the others which were dismissed on merit on 20th/11/2022.
Yes.
My lord, kindly consider. Then, my lord, kindly consider.
Dismissed.
My lord, kindly consider. Appeal has been dismissed so far this order sheet is concerned. My lord, kindly consider 28th November 2022. Now, my lord, kindly consider 28th November 2022. Kindly consider 28th November. My lord, here, my lord, kindly see page 10. It starts from page 106. This is his petition. I am not saying it. It is his petition I am saying. Kindly see. When he has filed December by the authority on December 22, 2022.
No, my lord, that was not.
Oh,
My lord,
my lord, this is his petition. My lord, I am not.
Please take note, the caption matter was filed by my client on November 25, 2022. And the matter was posted for hearing.
Yes, done. Now, let us see. My lord, his contention that appeal was filed after that. And hearing was given on December 22, 22. My lord, kindly consider. And neither me nor me, there was favored a copy of the order passed. So, my lord, he is seeking an order passed by the appellate authority. So, appellate authority has to challenge.
Attended the appeal on, appeared before the appeal.
I attended, my lord.
December 22.
December 22.
So that it was disposed of on 28th November.
My lord, that I don't know, my lord. That is my case. My lord, what I have written, if I emphasize the language written in this representation, my lord, my matter was filed by my client on November 25, 2022, and the same was heard by the authority concerned on December 22, 2022. And since then, neither me or my above named client was favored with a copy of the order passed in bracket, if any. So I don't know what was the exact situation of my appeal, my lord.
Copy. That's why, my lord, kindly dispose of this appeal, directing the authority to supply the copy of the order and challenge the same. And during that period, the whatever stay that will be
there be a proceeding, my lord, if a proceeding was initiated, I have a right under section 7 to file an appeal.
You have filed that.
I have preferred that appeal.
Yes.
Now that appeal have to be disposed of in accordance with law. My first contention is, my lord, whether 7
How can you, unless you get the copy of...
If my learned friend is trying to say that I do not have a right to appeal, my lord, that I don't know. My lord, my case was, I have preferred 7 different appeals. 7 different appeals have been preferred because 7 different cause of actions were there, my lord. My lord, the 7 different appeals have been numbered as appeal case number 3. My lord, this shows the intention that all the appeals have been clubbed conjointly and taken up together without going into the merit of my appeal. My lord, they went on disposing of on a date prior to the hearing. So this is the reflection what is contained in the order of execution passed. Look, that order of execution is under challenge before your lord.
Where are these orders? March 27 and March 28 orders,
My lord,
which you have challenged in this petition.
my lord, March 27, my lord, at page 103, my lord. 27th of March 2023.
You have challenged this order.
I have challenged this order, my lord. I have not challenged the order under section 4, my lord. That have been challenged. That is the subject matter of the appeal under section 7 pending before the DM.
Please come to your prayer, B. You are in fact challenging this order.
Lord, directions in the nature of mandamus directing the respondent number 2 to recall and or resign and or set aside the purported order dated March 27, 2023.
That's this order.
That is this order, my lord.
So how can you challenge this order before this court? You've preferred an appeal already.
My lord, this is the order of execution, my lord. My lord, this is not the order under appeal passed under section 7, my lord.
This is the order of execution. Yes.
This is the order of execution. This is under challenge. My lord, I have never been favored with a copy of the order passed in that appeal. Even I am not sure, my lord, whether that the appeal have been disposed of on the first place or not. My lord, 3 important things, if I may, my lord, if I be allowed to recapitulate once again, my lord. My lord, section 4 notice was given on a particular date. I preferred an appeal in the month of November. The date, the hearing of those appeals have been posted on December, my lord. Thereafter, our order of execution was passed in the month of March 2023. Now, in that order of March 2023, I came to know that an appeal which have been preferred, all those 7 appeals which have been preferred at my instance have been disposed of on a date that is on November 2022, whereas in their notice it says that the appeal should be posted for hearing in the month of December 2022.
I think for that reason, a report was called for.
My lord, kindly see they have also, my lord, filed a report on earlier occasion. My lord, this report has been prepared.
By the police, I think. So
That
it
is
was not
by police.
accepted by the court.
My lord, kindly see there is no utterance whether the appeal have been disposed of, whether the copy of such order for disposal of the appeal have been
Police
supplied.
is not supposed to say whether the appeal was disposed
My lord,
of.
but they vouch for the fact, my lord, that the order of execution was served upon me. My lord, in the meantime, before the order of execution and the section 4, there is a scope for appeal. Now that appeal have not been disposed of in accordance with law. That is my case, my lord.
Let this order be stayed.
My lord, kindly consider one thing, my lord. Kindly dispose of this writ petition. Why I am submitting? Because from 106 to 110, 11, kindly see, different persons have stated the same thing. You have, the hearing was made on such and such date.
How do you explain, how do you clarify this fact?
My lord, kindly consider, kindly make, my submission, I am making my submission in humble. What I am on? He did not challenge the parent order.
No.
He challenged the execution, order of execution. Order of execution, unless the parent order is, suppose parent order is challenged, he cannot say. Kindly see his grounds once more. Kindly see his grounds one after another. I am showing. See his grounds. For that, the respondent notice issued by the respondent is bad, 27 March. Next, for that point, pendency of the appeal. This is his.
You have issued the notice of execution before serving a copy of the order of the appeal.
My lord, kindly consider. That's why I am making my humble submission. Kindly direct the authority to serve the copy of the order, if any, passed by the appellate authority, and he can challenge that order of appellate authority before here, my lords, or any court of law, and due till that date, the execution to be stayed. Yes. That is the, my lord, that is the simple thing.
My lord,
My lord, that is because why I am submitting. My lord, in the background, my lord, I cannot narrate that. This is a hospital, government hospital.
That is recorded.
And my lord, acquisition, my lord, actually 40 years back.
Whatever it may be.
Whatever is back, 40 for 50 years back. So, my lord, it is, they are totally unauthorized occupier. My lord, at least, my lord, at least if he satisfy, my lord, this is the deed wherefrom he has purchased. My lord, matter ends.
That this court will not.
This court will not do. That's why, my lord, I am submitting.
Let if the appeal has been disposed of, let an order be given to you.
Yes,
If not,
until
it will
that
be
date.
heard again by the appellate
My lord,
authority.
may I humbly submit this, my lord?
Yes, now he is.
In the meantime, this order of execution passed on 27th March precedes on a wrong finding, my lord. Lord, that cannot sustain, my lord. It cannot be kept in error. This order has to be set aside.
This will be set aside.
My lord, that is my humble prayer.
This will be set aside.
Set aside to that effect, my lord, because appeal was heard after that.
Yes.
That's why kindly yes. That order of the appellate authority be
Heard learned
served.
counsels for the parties. An order.
And my lord, only thing, my submission is he did not challenge the parent order, original order. That is,
He has not challenged, the record says so, the
Yes.
decision says so.
yeah, he did not challenge because unless the parent order execution is arising out of that order, unless he
No,
challenged
The order does not even
Out of
exist.
Appellate order.
my lord,
Not-
no, my lord, subject to my lord's approval. Execution has been made or any order be passed on the basis of the parent order. Parent order he did not challenge. My lord, no, my lord knows the civil law. My lord, this is the my lord, foundation.
Perspective.
Yes. But my lord,
His grounds are different.
downside, but my lord, he did not challenge the main order on the basis of which executive order of
My
execution.
right to
My lord
challenge
knows
the
that
parent
civil
order lies
procedure
before
code.
section 7
My
before the
lord,
DM
kindly see,
concern, my lord.
7, that's why my lord, I am saying.
This is a section 4 order, isn't it?
My lord, from
10th,
section 4, I have a right to appeal under section
Yes,
7.
absolutely.
And I cannot come before this court to challenge that order, my lord.
An order under section 4 of the West Bengal Public Land within bracket eviction of unauthorized occupants bracket closed Act, 1962 was passed against the petitioners on 10th November 2022. Declaring the petitioners to be unauthorized occupants of the plot in question and directing enforcement of eviction of the petitioners from the said plot. Within a stipulated time frame. The petitioners carried this order in appeal and were informed appeal under section 7 of the Act of 1962, and the appeal was heard upon affording reasonable opportunity of hearing to the petitioners on December 22, 2022. Stop. The decision taken by the appellate authority has not been communicated to the petitioners till date. Stop. In the meantime, an order of execution was passed by the subdivisional magistrate, Barashat within bracket Shodor, North 24 Parganas on 27th March 2023, which records that the appeal filed by the petitioners the appeals filed by the petitioners and others, being appeal case number 3 of 2022, were dismissed on merit on 28th November 2022. Paragraph. No explanation has been given on behalf of the state respondents as to how the appeal was disposed of on 28th November 2022 as recorded in the order passed on
27th of March 2023.
27th of March 2023. Despite the fact that the appeal was heard in presence of the petitioners on December 22, 2022. Paragraph. On this ground alone, comma, this court is inclined to hold that since the order passed on 27th March 2023 is on the anvil of a wrong recording of disposal of the appeal, comma, the order is required to be set aside. Paragraph. Accordingly, the order passed on 27th March 2023 by the subdivisional magistrate, Barashat within bracket Shodor, North 24 Parganas is set aside. Paragraph. The appellate authority, being the, who is the appellate authority?
District magistrate.
Or if it is, yes,
Respondent
district
number?
magistrate.
My lord, 3.
3. District magistrate.
3, my lord.
Yes.
Being the third respondent herein, is directed to intimate the result of the appeal to the petitioners within 2 weeks.
My lord,
Result of the appeal to the petitioners within 2 weeks from date.
And
In
my
the
lord,
event-
if not any,
the appeal, please allow me to dictate this, Sringupta. In the event the appeal has been disposed of, and in case the appeal is still pending,
Yes.
give reasonable opportunity of hearing to the
Obliged.
petitioners and dispose of the appeal within 2 weeks. Within 2 weeks from the date of communication of this order. In accordance with law.
my lord, if I were allowed to, my lord.
Paragraph pending disposal of the appeal / communication of the order of appeal.
yes, no
to the
coercive.
petitioners,
Yes.
no coercive steps be taken against the petitioners
Obliged, ma'am.
in respect of the plot in question.
My lord, one
Obliged.
more indulgence, my lord, if your lordship kindly appreciate that there are 7 different appeals. My lord, kindly direct if the appeal have not been disposed of, then the individual
I've
here,
stated petitioners.
individual
Yes,
hearing should be
petitioner.
allowed to all the petitioners, my lord.
Other appeals, other petitioners, this court is not concerned here, is it?
My lord, there are altogether 7 petitioners under this writ petition, my lord.
The petitioners will be heard.
My lord,
Yes. Obliged, ma'am.
grateful.
That's why, my lord, I told my senior, I think it will be disposed of. Oh,
Accordingly, this, next.
I appear for the petitioner, my lord.
No, the
My
statement.
lord, earlier occasion, similar matter before your lordship.
What is the matter?
Petitioner is the highest bidder in the e-auction process. He has deposited 1/3 amount. Mining plan has been approved for environment clearance by the Chief Mining Officer, West Bengal. Applied for environment clearance before the district authority. Thereafter, in terms of the principal bench of Honorable Green Tribunal, my lord, the district authority is inoperative for issuance of environment clearance certificate. For the further petitioner applied before the state authority in the portal, that has been rejected or delisted on the ground that the area is not within the potential zone. That is not my fault. Earlier occasion, my lord was pleased to direct the
You
authority.
have asked for an alternative plot.
Yes. Similar order passed by your lordship.
Yes.
Representative may be considered, my lord. Though, my lord, there is no
Listen, I have
provision of, my
deposited
lord.
huge amount, my
alternative
lord,
plot.
already, my lord. That is their laches, my lord.
And the earlier say lordship, my lord, but there is no provision of alternative plot, my lord. If we want, my lord, alternative, then we have to, my lord, again auction, my lord, e-auction.
How can I do
That
that?
there is no
It is
provision
your
in the
fault.
rules. Rules. But
That you have to consider. It is your fault. You have allotted a plot which doesn't have the potentials. So how is the petitioner responsible? He has deposited the money.
can you direct the authority?
He can in fact claim interest also.
Yes.
Yes, my lord.
His money is blocked there, isn't it?
Yes, it is true, my lord. Let the authority may take a decision on this point. On earlier occasion, your lordship directed similar matter, similar order.
You have a representation pending.
Yes. Pending, my lord. Earlier occasion, my lord, directed to submit a report before your lordship. That matter is also pending.
Report will not be received. Why waste
Yes,
for the
yes.
time? Let them consider.
Dispose.
Where is your representation? I find several representations. isn't
Yes,
it?
several representatives, my lord. from page 48. Kindly give some observation, my lord, otherwise they will not consider the further.
These are identical representations.
But ADM is the authority. They have submitted
Actually,
representation
district
because
magistrate
the-
authority, he is the chairman of the district mining authority.
But the-
ADM is the delegated authority, he is signing the
but the
approval.
decision is taken by the ADM, ADM DLR, yes, ma'am.
Very well.
I have personally talked with the ADM, Purbo Bardhaman, my lord. He also informed me that order may be paid before your lordship, before the district magistrate, because he is the district mining authority as per rules, my lord.
As
Chairman
per
is the
rules,
district mining authority, district magistrate.
including the ADM, my lord. I have seen the rules, ADM and also the
District magistrate.
district magistrate, also the ADM. My lord. ADM is also the authority, my lord.
Authority, no, this is a delegated authority.
Affidavit of service. Being the highest bidder in a new auction floated by the authority, and upon depositing 1/3 of the bid amount.
G, my lord. Left side. District authority.
And include the additional district magistrate in charge.
She is the delegated authority, my lord. For this.
ADM DLLR is the dedicated authority. So let it be both ADM DLLR. He is a party.
Yes.
Yes, yes. Yes, ma'am. It's one of three.
Both are party.
You have impleted him?
It's
Yes,
not
the
three.
third respondent.
Yes.
And upon depositing 1/3 of the bid amount, comma, the petitioner was issued a letter of bid amount, comma, petitioner was issued a letter of intent was issued in favor of the petitioner. And the petitioner applied before the district magistrate, comma, Purbo Bardhaman, for issuance of environment clearance upon approval of mining plan by the chief mining officer, Asansol, Paschim Bardhaman. Stop.
Government of West Bengal.
In the meantime, comma, by an order passed on 11th December 2018, comma, the Honorable National Green Tribunal directed stay of operation of what? Of
the function of the district authority. Function of the district authority for issuance of environment clearance.
Stay of operation of the function of the district authority for issuance of environment clearance, and upon by a memo dated 17th February 2022, comma, the highest bidders were allowed to submit application, were allowed to apply for environment clearance before the State Environment Impact Assessment Authority within 31st March 2022. Stop. The letter of intent issued in favor of the petitioner was extended for a period of 6 months.
Time to time extended, madam.
Stop. The petitioner applied for environment clearance before the concerned authority on 21st February 2022. Which was turned down by the authority on the ground that the mining plan and application do not fall within the potential zone of the approved district survey report. Stop. The petitioner thereafter, applied for an alternative area in order to enable him to commence mining operation. Stop. Several representations submitted by the petitioner in this regard fell on deaf ears. Stop. The petitioner prays for a direction upon the authority to consider his representations and allot an alternative sand block in his favor so that he can commence mining operation.
Within the DSR area, district survey area.
In the
Survey area.
alternative sand block. In the potential zone.
Yes.
In the potential zone. So that he's able to. Paragraph, it is submitted on behalf of the respondents that the third respondent be directed to consider the representations submitted by the petitioner in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representations submitted by the petitioner within bracket annexure P5 to the writ petition, bracket closed, within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. The concerned authority shall consider allotment of an alternative sand block in a potential zone in favor of the petitioner in considering the representations.
Yes.
Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of the chapter. Take back your book. Next. 24.
Statement.
Well, I beg to appear on behalf of respondent.
24, I am appearing for the petitioner, my lord.
On the last occasion, this was taken up. My lord, whether this matter belongs to my lord LRTT or my lord before this honorable court.
My lord,
My learned friend is
kindly hear my submission, my lord, first, my lord. The lands belong to the, my lord, 1 minute. The lands belong to, my lord, one Taragoti Samanto, being the predecessor in interest of the private respondents, my lord, who got the property by way of settlement, my lord. By getting that property, my lord, said Taragoti Samanto had been possessing the land by making Paka, Kacha construction, as well as, my lord, Taragoti rice mill and, my lord, Komola rice mill. This is the issue in this matter, Komola rice mill. My lord, after that, my lord, the predecessor in interest of the land devolved upon the private respondents. Their names had been duly recorded in the KB record of rights, my lord, as would be appear from the record of rights being annexed in this petition, my lord. After that, my lord, the petitioners had purchased the land in the year 2010 by way of registered deed of Kabala. Since then, my lord, they have been possessing their lands by making construction over the lands, my lord, measuring about 2.38 acres. There are so many buildings constructed by the petitioner. Their name also have been recorded in the LR record of rights, my lord. classification of the land Bastu/rice mill, my lord. They have been possessing till now. In the meantime, my lord, kindly see page 128, my lord. On the basis of the right to information application, BLR communicated the petitioner number 1. Kindly see, my lord, this is very important, my lord. Got it, my lord?
120.
And my lord, 118.
Yes.
Regarding query number 1, my lord, it is stated that plot number 2237 of Mauja Patpur, J number is currently not vested to the state. This is the very much important, my lord, in this case. My lord, my senior is coming, my lord, who is leading in this.
Lordship, this is the matter, Lordship, where the land is not vested in the state. Now, there was an application. Lordship, kindly come to the next page. That is 119. This was addressed to me with reference to your petition dated 21/4/2016. Subject noted above, I am directed to forward herewith a copy of memo bearing number such and such dated 23rd/11/2015. Now, after that, it was 23rd/11/2015, the next memo which was issued and which is presently under challenge, which says that 120, Lordship, whereas lands measuring more or less 2.38 acres of land comprised in the mill held by Kamala Rice Mill, hereinafter called the said mill at Mauja Patpur, jail number 212 and under police station and district Bankura vested in the state government free from all encumbrances under section 5 of the West Bengal Estate Acquisition Act 1953. And whereas the said mill held that the said 2.838 acres of land for the purpose of running the said mill under the department's order number such and such under subsection 3 of section 6 of the said act. And whereas it is clear from the reconnaissance survey report that the said mill is closed for 40 years and the said area of 2.38 acres of land is lying unutilized for the purpose of the said mill for long. And whereas preliminary hearing was given to all materially interested persons concerned by the district authorities of Bankura in respect of said 2.38 acres of land. And whereas the state government has considered to resume the said area of 2.38 acres of land as being surplus to the requirement of the said mill for which it was so allowed to retain. Now, Lordship, here I raise the issue that when I am I'm living on that particular land after constructing my house and dwelling houses are there, mill is not there. These can be inspected. It can be detected from any physical inspection of that particular spot that my houses are standing there. Now, Lordship, this in that premise, this order has been issued stating that mill which was closed 40 years back, now that mill requires no extra land which state government wants to
The entire consideration is under the West Bengal Estates Acquisition Act.
Yes, my lord.
And the further notice is under the West Bengal Land Reforms Act.
Yes.
Section 50 and 57. So
Yes.
this court doesn't have.
Now, Lordship, only one thing, I'm only seeking a limited relief from this court that there was let the estate acquisition, the courts under the Estate Acquisition Act, let the petitioner take the recourse. But Lordship, let them consider the contentions raised in the writ petition, particularly in respect of the
That cannot be
presence of
directed by this court. You have to file a fresh application before the appropriate forum. Annex all these documents that is there.
so far this is concerned only thing, Lordship,
Take
that
the same submission before the appropriate authority. I'll grant you liberty to approach the appropriate authority.
Lordship, we will let us challenge this memo before the appropriate authority.
Yes, absolutely. Is there any question of limitation?
Yes,
But
ma'am, there's a
only question is
This order has been passed in 2050.
that only
There is a
that limitation is apart from that, Lordship, limitation may be condoned by this court. Only question is that whether this order can be challenged. Because this is the order which is passed under the Estate Acquisition Act. And now this estate, under the Estate Acquisition Act, the authority is there, not related. The appropriate authority is there. Now, Lordship, I am only one Supreme Court judgment which I want to rely, 2002-4 SCC 188, which says that West Bengal Estate Acquisition Act 1953, right of intermediary to retain the land appertaining to the buildings and structure owned by such intermediary, held intermediary need not be the actual possession. His right to retain is not affected even if building and structures have been leased out.
You're on merits.
I'm on merit. So, Lordship, this
This
is,
authority will consider.
Lordship, kindly direct him to consider.
I'll relegate it to the
Particular this
authority.
order has to be challenged before they
Yes.
indicate that, Lordship.
You are challenging the subsequent notice also?
I'm
20th
challenged all
March.
subsequent.
Yes.
May I deal with the matter?
The order
No. It can be.
passed by the Deputy Secretary to the Government of West Bengal on 23rd November 2015.
Lordship, only one thing, that if at all any limitation is there,
I'll
kindly
condone it.
condone
Yes,
it.
yes.
Grateful, my.
Let them decide on merits.
Yes, my.
And notice under section 50 and 57 of the West Bengal Land Reforms Act 1955, issued by the Block Land and Land Reforms Officer, Bankura -Roman 1 on 20th March 2023 are assailed in the writ petition. Stop. The matter pertains to the West Bengal Estates Acquisition Act and the West Bengal Land Reforms Act. Paragraph. Learned counsel for the petitioners seeks to approach the appropriate forum for redressal of the grievance of the petitioners. Paragraph. In view of the above, the writ petition being WPA such is dismissed for non-prosecution. Paragraph. Liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Stop. Paragraph. In the event the petitioners approach the appropriate forum within 15 days,
Yes, madam.
within 15 days from date, the appropriate forum shall consider the case of the petitioners on merit without dismissing the same on the ground of limitation.
Madam.
Paragraph. There shall, however, be no arrest to costs as a certified website.
Grateful, my lord.
Next.
I am for the petitioner.
Affidavit of service.
Affidavit of services.
No, the statement.
My lord, actually, petitioner is a 70 years old lady, and
Mr. Kottapan, you are
Yes, ma'am.
the battle is going on since 1998. What was the contention? One of contention was this, that we were telling that the 11 decimal of land on which government has constructed a metal road, that land is mine land. But the government stand was that no, that is the extra land. So one representation was given, and by the order of the court, that representation was considered and rejected. Then we came before the single judge dismissed it. Then we appealed before the appeal court, and that order is at page 22. Page 22. Pursuant to an earlier order dated 25th February 2019, the concerned revenue inspector and the present BL and LRO are present in court. This is a unique case where the land of the petitioners has been found to be in excess, although the original 3 plot numbers have remained unchanged, and the BL and LRO in its initial report of 2nd September 2014 has found that the total land of the writ petitioners in the 3 plots aggregate to 305 decimals. This record was of recent origin, and it is now contended that the said report prepared by the BL and LRO Pathor Pratima South 24 Parganas was erroneous. Now, as per the BL and LRO report, the current measurement of the said 3 plots yields a total land measuring 317 decimal, and it is sought to be defended by contending that quantum of land involved in the road is 11 decimals as per the recent report prepared by the BL and LRO. The recent report states that the said round was constructed in the margin line of 1 and 2 number sheets of that Murja map, and due to certain of extra land from margin line, the recent measurement shows extra land. However, in the report under challenge, it is also contended that the land of the petitioners was not encroached for the construction of the said road. The statements in the report are irreconcilable. For our convenience, we requested the revenue officer to be present in court to explain the contradictions in the 2 reports. The revenue officer has contended that when sheet number 1 and 2 are joined, it was found on the margin line there are an additional 11 decimal of land. The existence of this land, however, had never surfaced in the past. This court is at a loss to understand how the margin line of sheet number 1 and 2 could create a new land measuring 11 decimals. This appears to be more imaginary than real. In any event, on the basis of such report, the original holding of the petitioners are affected. On such circumstances, the order dated 9th October 2014 passed by the district magistrate have been pleased to pass an order on 6th March 2019 inter alia, setting aside the order passed by the district magistrate dated so-and-so and the impugned order dated so-and-so, that my clients have demanded justice by letter dated 28th March 2019, but you pay no heed to the prayer. In view of the above, you are requested to take immediate action to pay my client's compensation for illegal encroachment of 11 decimal land as per present market value, failing which I shall have no option but to instruct my client to proceed against you in the court of law. And so they didn't do anything. After that, my lord, I filed a review application before the division bench. Why? Because I already prayed for the compensation. So kindly allow me compensation. They said that no, you go before the appropriate authority. Then for speedy things, we filed an SLP. And the SLP notice was issued to all concerned. After that, my lord, at the time of final hearing, due to technical fault, their lordships could not hear me. So they dismissed our petition. And after that, when I made a review petition before the Supreme Court, that time the review petition, they said that already you have been given the liberty, so you proceed in accordance with law. Then we made the first complete remedy. We made a curative petition. It was also dismissed because they didn't hear me. Only in circulation, the review petition and curative petition were dismissed. So, my lord, my humble prayer is this, that as it is established that the land is not extra land for which these 25 years are going on, battles are going on. So kindly pass your lordship in order so that I am an old lady, I can get my
Yes.
compensation.
Division bench,
There is nothing much to decide in this matter.
Yes.
It has been decided.
yes,
You
decided.
can only pay compensation.
Then can you direct the authority to consider their representation on the on
This is
compensation
not a
part?
representation. This is a demand of justice.
Yes, let them file a comprehensive representation before the authority. This has been decided, but there is no direction of the division bench to pay
The
compensation.
court, now I'll give a direction. No representation is
Direct
necessary.
the authority to take a decision only in accordance with law.
Even after the decision of the division bench,
Since the issue has been decided,
nothing is left to the authority also. It is decided that the land belongs to the petitioner.
yes, that has been decided. But
You have to pay compensation for it.
let them authority take a decision, on the in accordance with law, my lord. If the land is acquired
Then
or
again-
utilized, the authority will take step, my lord. in accordance
Again,
with law, my lord.
several years.
Instead of mandatory order, my lord, kindly
If the land is acquired, then compensation. If not acquired, they have to take steps for acquisition or direct purchase.
Fine.
Yes.
Grateful to
yes.
Let there be an order to that effect.
deeply
Let the authority take a decision, my lord. Only my prayer is there, my lord. Since we have not received any
Yes, I'm
instruction,
giving three options to the authority. They have to decide between three options. Either direct purchase or compensation or acquisition. These are the three options.
yes, my lord. These are three options.
So
Let them take a
that's the
decision.
choice. That is the choice of the authority. Any one of the options among these.
And so we have not received any instruction in this matter. That is why I am praying, my lord. Let the authority take a decision on the basis of the comprehensive representative of the petitioner. And if it is, my lord, acquired or utilized, the authority will take step in accordance with law, my lord. But instead of my lord, passing a mandatory order, my lord, only I am praying, my lord, let the authority take a decision.
This is a different case. It's not similar to the other cases where the petitioner can file a representation and the authority can consider. There is no chance of consideration by the authority. It has been decided by the court.
Let the my lord, place the division bench judge before the order of the authority on the basis of the division bench judgment order. Since there is a direction by the division bench.
They'll be given an opportunity of hearing. They can place relevant documents.
Yes, madam.
Affidavit of service. Heard learned counsels for the parties. It is contended on behalf of the petitioner that out of the land owned by the petitioner, 11 decimals were encroached upon by the state respondents and no compensation has been paid to the petitioner for the same. Stop. Pursuant to an earlier order of this court, in page 22 of this court on 9th June 2014 in WP number 14710 within bracket W of 2014, a representation submitted by the petitioner before the concerned authority was disposed of, contending that the 11 decimals of land was extra land not belonging to the petitioner and was not encroached upon by the authority. The said order was challenged by the petitioner in a writ petition being number 30211 within bracket, being number bolam na, repetition to aage bolechi. Being number 30211 within bracket W of 2014, which was dismissed by an order passed on 24th August 2018. Stop. The order was carried in appeal by the petitioner and an honorable division bench of this court, by an order passed on 6th March 2019 in MAT 1218 of 2018, set aside the orders passed on 9th October 2014 by the district magistrate, as well as the order under appeal passed on 24th August 2018, with an observation that the land measuring 11 decimals could not have been extra land and the original holding of the petitioner was affected by the encroachment. Stop. In other words, the court held that the 11 decimals of land in question were part and parcel of the land belonging to the petitioner. Pursuant to such observation, the petitioner approached the concerned authority claiming compensation for utilization of the portion of her land without acquisition. Stop. Paragraph. Learned counsel for the petitioner submits that no step has been taken by the authority for redressal of the petitioner's grievance till date. Paragraph. Upon consideration of the submission made on behalf of the parties, this court is inclined to hold that in view of the observation/direction of the Honorable Division Bench, the state respondents are left with 3 options, : to purchase the land directly from the petitioner at the prevailing market rate, to acquire the land in accordance with law, or to pay compensation. 2 options. 2 options. 3 options. Are left with 2 options. 2 options. And to acquire the land in accordance with law and pay compensation for the same to the petitioner. Paragraph. In view of the above, the writ petition is disposed of, directing the ADMLR.
No.
Who should be the authority?
My lord,
respondent
part
number
2 is the authority. LA collectors,
Yes.
Let's
LA
part
collector.
2, my lord. Let's part
Directing the second respondent to take necessary steps for direct purchase of the plot in question or for acquisition of the same in accordance with law, following payment of compensation, followed by payment of compensation to the petitioner. Upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner. Stop. The entire exercise is expected to be completed. I give you 4 months. Within 4 months from the date of communication of this order.
Great.
Disposed of which
Seems to be a mandatory order. It seems to be mandatory.
Has to be. The court has mandated. The division bench has mandated.
But division
So
bench,
after that, you're not left with any option.
no order, I say no order has been passed by the division bench. They could have, my lord, preferred, my lord, a review application before the division bench, my lord.
They had filed a review application.
that has
The
been,
division
my lord,
bench has
this
asked
is
them
by
to
the-
approach the appropriate authority.
No, that has been
So if you
the
feel that this court is not the appropriate forum, you can go and appeal. I don't think that will help you much. You have to comply with the order. Next.
26.
I am for the petitioner, my lord. I have served all the respondent, my lord. Affidavit of service, my lord.
I'm appearing for the state respondent.
My lord, petitioner is the owner in respect of the plot number 63/85, just beside the roads, my lord. But between the roads and the plot of the petitioner, my lord, slight land, my lord, small land, my lord, occupied by the PWD, my lord. That was, my lord, the private
You have
respondent.
not served the private respondent.
Yes, my lord. Yes. One, my lord, only, my lord, one person is yes, my lord.
So that only one person will go to appeal and say that I have not been served.
All are sent, my lord. But kindly see, my lord, all items were delivered, delivery confirmed, my lord, one, my lord, only one.
Please serve and come back.
Yes, there's a good ground for
This becomes a
appeal.
ground for appeal unnecessarily.
Yes.
Only for, my lord,
So that
consider,
one person will have a right of appeal.
giving opportunity of them also, my lord. Giving opportunity of them also.
Primarily, they have to be served. Please serve and come.
It will be better for my land understanding.
Yes,
It is better for my land understanding
Absolutely.
because
otherwise it will come back again.
yes.
Pintu Das has not been served.
Yes, ma'am. Only been to this, my lord.
Affidavit of service. Since,
Should be pink.
since the 11th respondent has not been, since service upon the 11th respondent is not
Effective.
complete, comma, let the matter stand over till 17th August.
Grateful.
17/8
My lord, I am for the petition. My lord, I am praying for short passover. My lord,
Not possible in this court.
my lord,
Please make your submission.
my lord, in this matter, my lord, my learned senior is engaged on another.
Maybe
my lord.
make your submission. You are ready. On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 22nd August.
My lord, the time to extend, my lord, to file the affidavit, my lord, a report on affidavit, my lord.
You are
That-
asking for extension.
My lord, yes, I see.
27, 28.
Learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as called for. Tapore paragraph on prayer of the petitioner, the matter is adjourned.
My lord, 28 and 29.
3 weeks time, maybe.
22nd August, I said.
22nd.
Bolo na kya?
My
Next,
lord, 28 and 29 are the same matter.
yes,
This similar matter,
Similar
same
matter.
matter.
28 and 29.
28 and 29, similar. You are asking for
28.
extension in these matters also?
Same, same.
Same order, 28, 29.
29.
Yes.
30 to 29, that's agreed. 30 to 29. 30 ready? Short matter?
My lord, all three.
30 minute I am for Union of India.
31 I am for the petitioner, my lord.
30.
30. My lord, the petitioner is the owner of the certain plot of land. At
Union of India, who is appearing?
I am for Union of India.
You are appearing? Yes.
Eastern Coalfield Limited, no one is appearing for Eastern Coalfield
Yes,
Limited.
he's the answering respondent, my lord.
He's
I have
answering.
come, my lord. Earlier occasion
Where
appear.
is your ECL, yes,
Earlier occasion appear, my lord.
yes, others were appearing.
Yes.
Said, Nurul, Arfin, Rahul Singh. Yes,
Yes.
you're appearing for the ECL?
Yes, my lord.
Yes. Short matter?
Yes, my lord.
Short matter, my lord. I am the owner of the land. As I have got the property by way of registered deed, then there is no dispute at all. There, my lord, the certain the particular land, the ECL authority concerned, occupied and demolished the wall. My lord. My respectful submission is that if it is acquired, then it has been acquired on the basis of by following the procedure of law. It has not been followed. I have filed an application and my lord, application on RTI Act. There, my lord, they are saying kindly consider page 44. This is their answer. Then it is not confirmed by the authority concerned that it is their land. It is my land. I am the owner of the land, my lord. Registered deed. It has been annexed here. And how they are trying to demolish. Already, my lord, wall has been
Under process of searching.
searching, my lord. They are searching, my lord, for some long days, my lord. This is the last time I have filed an application. Before that, my lord, already wall demolished.
So a portion of the land has been encroached upon by the ECL.
They are saying, ECL authorities view that it is their land. I am the registered deed, kindly consider, I have the annexed hearing. Then it is the evidence, my lord.
Yes.
My
What
lord,
do you say?
this land was, my lord, already purchased, my lord, by Bengal Coal Company, my lord, in the year 1963. I have a deed, my lord. Your lordship seen, my lord,
Why
that
don't you come back with a report in
I
that
will come
case?
back with the report, my lord. I shall annex all those things, my lord. And my lord, thereafter, my lord, nationalization happened, my lord. And my lord, the land has been handed over to ECL, my lord. Now, I will also show photographs, my lord. In that land, my lord, we have also enclosed, my lord, board, my lord, that this land belongs to ECL. They know about that, my lord. Thereafter, they have purchased this property, my lord. Even thereafter, my lord.
Subsequent purchase.
Subsequent purchase, my lord. My lord, even knowing that, my lord, they have purchased, my lord, I shall say, discuss everything in my report, my lord.
You have got the land by way of acquisition or purchase.
By purchase,
By
my lord.
purchase.
It was, my lord, purchased by the Bengal Coal Company, my lord, in the year 1966.
Come back with the report
Yes, ma'am.
annexing all these relevant documents.
My lord, I shall, my lord.
Both the petitioner and the Eastern Coalfields Limited claim to have acquired title in respect of the plot in question. Paragraph learned counsel for the ECL seeks to submit a report in the form of affidavit in this regard. Paragraph, please serve an advance copy to the
I
petitioner.
will certainly.
Let the matter appear under the same heading on 23rd August.
23rd of
2023. But my appearance has not been recorded.
Please mention when the mentioning time is there.
My
This
lord,
is not mentioning
my lord,
time.
kindly excuse me, this item number 204 is extremely urgent. Petitioner is going
This
to
is
be,
not the mentioning time, sir. I'm
Yes.
sorry. Yes,
petitioner
call the
is going
next
to be
list, please.
evicted tomorrow from National High.
Please. This is not the mentioning time.
সকালে মেনশন করুন
The petitioner does not intend to proceed with the application any further. Paragraph in view of the same, contempt application being CPN such and such is dismissed for non-prosecution. Paragraph, there shall however be no order as to cause urgency required. Disposed of, is disposed of. Side name, service name. I'll just dispose of them.
Lordship, I'm appearing on behalf of the petitioner. On 15th of May 2023, Lordship directed to petitioner to file supplementary affidavit. So I'm filing today, filing the supplementary affidavit on behalf of the petitioner. So I'm filing the supplementary affidavit in compliance with the order dated 15th of May.
Have you served the other side?
I'm serving by today.
Now,
I'm serving by today.
you should have served an earlier, isn't it? An advance copy should have been made over.
But I'm serving by today.
Please go through this and.
My lord, one thing, one can application filed by the addition of party, can be disposed of addition of party. Otherwise, matter will be hard.
Yes.
Lordship, if I may submit with all my humility. Lordship, as I just submitted before that, all the conditions have been just fulfilled by your petitioner for the registration or renewal of the registration of the electric vehicles, battery operated electric vehicles manufactured by your petitioner. So it is the responsibility of a registering authority to verify whether the conditions have been fulfilled. And according
Do
to
you have any difficulty if the intervener is included as party respondent?
Actually, he does not have any weight. Actually, he does not have any weight. He comes here and also protracts the hearing. There is no connection. What he is just alleging, there is no connection with the title suit being number 27 of 2018 as was pending before the Alipur court. There was no connection because as I've already submitted it, Lordship kindly comes to paragraph number.
So in that case, let us hear, if you're ready with the application, let us hear
Yes.
the intervener first.
Lordship, may I just submit? Just only,
It is
I'll
his
just take only
application.
one. I'll just take
It is
only
his
1 minute.
application, so he has the first right of audience.
Yes, absolutely. I appreciate Lordship, but may I just submit only 1 minute? Just one. Lordship, comes to paragraph number 8 of the
Application
supplementary affidavit.
of the,
Supplementary affidavit. I've just.
I cannot consider that because you have not served copy. Isn't it?
Lordship, I'll just submitting. Just
So if you want, if you wish so, let this application be also taken up on the next date. After you serve copy of the, you cannot rely on the supplementary affidavit now. You should have served in advance.
Lordship, I'm
Because they are in the
will just
dark,
submit-
isn't it?
I'll just serve all the supplementary affidavits by today on.
Please do that. Please do that.
I will do that.
He'll file the supplementary affidavit today. Let these applications be taken up together.
My lord, the copy of
the writ petition
may kindly be served.
Not now, only after your application is allowed.
I am not aware what my learned friend
is
making.
You're not supposed to be aware.
Well,
No, my lord, the copy of supplementary affidavit or
Yes,
any
yes.
related with
Yes.
some can take
Supplementary affidavit submitted on behalf of the petitioner is taken on record. You have to serve only the state respondents.
yes, I'm serving now.
Paragraph copy of the affidavit is made over to learned counsel for the state respondents in court this day. Paragraph, the matter is adjourned. In view of the same, the matter is adjourned. Let the matter appear under the same heading on 25th August.
Lordship, it was difficult, so can it be kept on the first week of the August?
Yes, if you can place it before some other bench, because I'll be at Jalpaiguri.
My lord থাকবে না। My lord, kindly record that the supplementary affidavit served upon.
I've stated, I've recorded.
My lord, copy of the intervention application has also been served upon the state, my lord. May kindly
Copy of the?
intervention application has also been served upon the
Yes,
state.
there's no dispute.
25th. Great.
Next.
20.
I am for the petitioner, my lord.
My lord, I am for the state, led by Mr. Naik, my lord.
The last occasion, my lord.
My lord directed us to file a supplementary
Yes, your
report.
No,
My lord,
Report.
my lord, due to this panchayat, my lord's problem, there is a error, my lord.
Problem, that is over. Please don't make these submissions now.
No, my lord, kindly, my lord, give me only 2 weeks time, my lord.
You had asked for extension on the earlier
Yes, my
occasion
lord.
also.
Your lordship was pleased to grant that extension.
Yes. Please file your report on the next occasion.
Yes, my lord, yes, my lord, definitely, definitely.
Learned Counsel for the state respondents seeks further extension because the report is necessary.
Yes, my lord.
My lord.
Seeks further extension of time to submit the report in the form of affidavit as intended. Paragraph, let the matter appear under the same heading on 25th August.
Illegal operation or authority at Galore. Without valid permit, without valid registration.
Let them come.
That is the ground.
Next.
208.
But in this matter, only I am appearing for the writ petition. Your
Yes.
service has been effected. 3 and 4 has accepted service, but my lord 1 and 2, this is refused.
Refused. That is service. So who is appearing for 3 and 4? BSNL.
Yes,
There is a separate panel for the BSNL, isn't
the
it?
short point is this, my lord. Since 2009, though exchange is in my premise, my lord, they are not paying any rent, nothing of the sort. This is the only point. And I have been
File
told,
your affidavit of service?
but it is being typed, I am giving this.
Affidavit of service, sir.
Yes, already.
Where is the affidavit of service?
I will file the affidavit by tomorrow.
So let me file give you an adjournment because I do not find the respondents. If you can inform learned counsel who represents the BSNL, if you are aware.
Lord, I have informed them that 21st July it was fixed by your lordship. I informed them. They have received, 3 and 4 have received. Not that I have not served.
Since
Kindly have a look to this. Kindly have a look to this.
That's all right. Since affidavit of service is not ready, let the matter stand over till
Short date be given me.
16th August. Oh, জানেন না কি?
209.
My lord, I am appearing on behalf of the petitioner, my lord. May I permit you to file the affidavit of service? My lord, being aggrieved by the impugned order passed by the RTO dated 2nd June 2022, I have come before your lordship, my lord. My lord, page 36, running page 36, my lord, my application under section 80, my lord. 22nd August 2019, I filed an application praying for grant of permit in respect of the route, my lord, Kollani station to Triveni station, my lord. My lord, thereafter, no meeting, no hearing was held, and being aggrieved, again, I was compelled to file and writ application, page 40, my lord, and the order was passed in that writ application on 1st December 2021 by Her Honorable Justice Moushumi Bhattacharya, and the order was passed that proper hearing should be given to the applicant, my lord. My lord, thereafter, without serving any notice upon me, hearing was conducted by only chairman of the RTO, my lord, which is contrary to the provisions of the Motor Vehicles Act, my lord. Because along with the chairman, there has to be another two officers, my lord. And without serving any notice, the hearing was done. And the reason for rejection of my grant of permit was that the said route is having the more than 30% bus route, which is not correct. And the second thing, my lord, the area is congested, my lord. My lord, if your lordship kindly consider these photographs, my lord, in the said route, there is actually no direct bus route, my lord.
Photographs doesn't mean anything.
No, one thing, my lord, this structure in the route where this yellow structure is lying, there cannot travel any bus, my lord. So this is the thing, my lord.
Where is the order impugned?
My lord, order impugned is running page 43, my lord.
43?
43, running page 43, my lord.
It is said that you were given a notice was served.
No, my lord, no notice was served upon me. Nothing, my lord. Before this hearing, my lord, I made one written correspondence in Bengali. Before that, there is an order of this Honorable High Court.
Let the state respond to this.
My lord.
Was the petitioner heard before the order was passed?
Lordship, that I don't.
That's the primary question.
I am coming, my lord, only one point, my lord. Lordship, can you see? Ordered, my lord. Also since last paragraph. Apportioned route has been surveyed, MBI Node, which is Peru, the account that the route is more than 30% covered by bus route and falls under the district of Kullani station area is congested with violates the clause 5, 2 and 6 of the notification dated 29 January 2010. Lordship, kindly see my next page. Page 44, 45. Relevant provision, my lord. Clause 2. No new auto rickshaw permit should be granted in routes and area covering more than one district. Here, my lord, two districts falls. Nadia and Hooghly. That cannot be, my lord, entertained. If my lord has pleased to remand back, then no fruitful result will be there. Because there are restrictions.
But the petitioner was not given an opportunity of hearing.
That is lordship can give in a hearing. That I don't know.
Can you show me? Because in the order says that they were given an opportunity. But please show me service of notice.
That has to be, my lord. I have to. Otherwise, my lord, he cannot sustain. On the next district, he cannot sustain in view of the notification.
My lord,
how will the next hearing help you if you're even heard?
my lord, in this respect, may I permit it to place two points, my lord. One is that notification. The last, yes, I agreed that there are two districts, my lord. The main area, the total kilometer is 11 kilometer, my lord, within which Nadia is having 7.9 kilometer and Hooghly is having 3 kilometers, which is outside. In favor of my humble submission, lordship, in that notification, my lord, kindly consider the last line. The government in the transport department shall only be competent to grant any relaxation in the matter. So there's a scope, my lord. There's a scope. And second thing, my lord, if your lordship kindly consider Rule 111, Sub-Rule 2, the original transport authority may issue permit having validity in any other region in accordance with any general or special resolution recorded by any other regional transport authority, and any permit so issued shall be of like effect in the region of the other transport authority as if it were issued by that transport authority. So there is a scope. There is a liberty granted to the transport authority, my lord, with regard to the other district. Apart from this, I have to get an opportunity of being heard. So rest is upon your lordships. my lord.
Mr. Debroy, primarily you have to show that the petitioner was heard.
That has to be,
You'll come back with a report.
that is better, my lord. Some instruction.
Report specifically showing, indicating that the document that the petition was served, yes. Because it says, the order says that petitioners did not appear.
Yes. Yes.
So it should be non-appearance despite service.
Yes. Well, another thing, the rule, the source part is another big deal. This is not auto rickshaw. Auto rickshaw, my lord, governed by this notification issued in terms of the High Court's order.
The last line says the government can relax the.
That is called government domain. Government till that no relaxation has been made. Relaxation has been made regarding KMA or like that. That has
So
been
please
relaxed.
show me that it has been served at least so that I can deal
That
with
is-
the
that-
petition. Yes.
That is not survive his case also. my lord.
Affidavit of service. The petitioner challenges the order passed by the Transport Department.
RTA no diya.
Passed by the
RTA vote no diya.
by the district magistrate and collector and chairman RTA, Nodia on 2nd June 2022, primarily on the ground that no opportunity of hearing was granted to him prior to passing the order. Paragraph: Learned Counsel for the respondents seeks to submit a report in the form of affidavit annexing relevant documents to indicate that notice of hearing was served upon the petitioner.
My lord, one humble danger is the order was passed by the chairman single-handedly.
The
Because-
chairman RTA Nodia.
Yes, but provision says that there has to be another two persons. Total three.
Only communicate.
No, my lord. No board was
No,
formed.
he has not communicated. He has passed the order himself.
Yes.
Himself cannot.
Provision says that there has to be three members, my lord, including the chairman.
Primarily যেখানে বললাম,
Has to be inquired into.
without serving notice. Learned Counsel further submits that the order impugned was that a hearing was held by the chairman RTA alone in absence of two other members in violation
Fine.
of the provisions of law.
Section 68 of the Act, my lord.
In violation of section 68 of the Motor Vehicles Act 1988. তারপরে report. Let the matter appear under the same heading on 28th August.
My lord, subject to your lordship's convenience, apart from 24th to 28th August, will it be
29th,
29th.
29th August.
And 210.
My lord, in this writ petition, earlier service was made, but since the respondent were unrepresented, your lordship is of the view to serve again. So my lord, I have served them again. And they have received the notices, my lord, as per the track report.
The Jammu and Kashmir and
My lord, earlier writ petition was disposed of with some deductions. My lord, page number 49 of the writ petition.
Mr. Debroy, Transport Department, Jammu Kashmir, who appears?
I don't. Normally it's the.
Delivered twice. Let me deal with the matter. Yes, what is your
My lord, may I take your lordship to page number 49 of my writ petition? My lord, none appears for the respondent despite service. It is contended on behalf of the petitioner that despite an order of injunction granted by the civil court in title suit number 27 of 2018, restraining the respondent from repeating any infringement of the plaintiff's patent, petitioner herein, patent and from registration of battery operated eco-friendly e-rickshaws till disposal of the suit, which was modified to the extent that respondent authorities are at liberty to register battery operated eco-friendly rickshaws in the name of assignees whose particulars are mentioned in modification application. The respondent have issued the impugned order on 17 August 2021, according to sanction of registration of e-rickshaws under commercial segment with certain stipulations. The said order is assailed in the writ petition. It is submitted on behalf of the petitioner that an application under Order 39 Rule 2A of the Code of Civil Procedure has been filed before the civil court, which is sub judice. Petitioner has submitted a representation in this regard before the concerned authority on 30th August 2021. Which is yet to be considered. Petitioner prays for a direction upon the authority to consider the representation at the earliest. Upon consideration of the submission made on behalf of the petitioner and materials on record, the writ petition is disposed of, directing the second respondent to consider and dispose of the petitioner's representation. Consider and dispose of the representation submitted by the petitioner dated 30th August 2021 within 1 month from date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Since the respondents are not represented, petitioner is directed to serve a copy of the representation along with the copy of this order upon the respondent at the earliest. With this aforesaid directions, WP 25775 of 2022 is disposed of. My lord, thereafter I have communicated the order along with the representation at page number 51 collectively. My lord, page number 53 is the track report. They have received the same representation.
Is there?
My lord, 55 is the impugned order. Again, they have, without affording an.
51 is the representation.
My 52 is the postal receipt, my lord.
Yes.
My lord, in the page number 53, my lord, track report I have annexed. The respondent received the representation on 31st/3/2023, my lord. My lord, thereafter, again on page number 55, my lord, very shockingly, my lord, they have again issued an order without affording an opportunity of hearing. My lord, this order has been assailed in this writ petition, my lord. My lord, title suit number has also been given. Court directions in Kanishina versus State of West Bengal and 29 others. My lord, may I take your lordship to one more fact, my lord? Page number 10, page number 21, my lord, of the writ petition.
Yes.
My lord, defendant number 10 is the state of Jammu and Kashmir in the title suit. My lord, despite
so parties to the suit.
My lord.
So let the same order be passed.
My lord,
Let them consider your representation.
my lord, setting aside this letter, because my lord, they have not given me the opportunity. And my lord, I have challenged this letter also in my writ petition, my lord. My lord, my prayer is at page number 14. A writ in the nature of mandamus commanding the respondents to resign, cancel, withdraw the impugned order number 44-MVD of 2023 dated 28/4/2023, issued by Joint Transport Commissioner Jammu.
Have you submitted a representation?
My lord, I have submitted.
That is only a communication of the order.
My lord, that was directed by your lordship that I have to communicate the order copy along with the writ petition to the respondent, which I have communicated along with the representation, because representation was annexed with the writ petition. And my lord, they haven't considered, they haven't provided me an opportunity of hearing, and they have put.
Representation. This is only a communication of the order.
My lord, representation is at page number.
Have you filed a representation along with this?
My lord, page number 38. My lord.
38.
30. My lord, operative part starts from 39, my lord.
This is an earlier representation.
My lord, this was directed to be considered by the authority, by your lordship's order.
Earlier, yes.
Earlier, my
That
lord.
was considered.
My lord, it has not been considered
This is a
because,
different issue altogether.
my lord, it has not been considered because there was two terms mentioned in your lordship's order. My lord, there was a specific direction to provide a hearing opportunity upon consideration. So they need to issue me a notice of hearing. They haven't issued me a notice of hearing. They haven't invited me for a hearing opportunity. And my lord, nothing has been done, my lord, in regard to that order, my lord. Thereafter, they have proceeded to pass this order. My lord, I am aggrieved by that because hearing has also been not given to me, my lord, as per your lordship's order. No hearing notices has been issued. Lord, there was a specific mandate of your lordship of hearing to all the interested persons, including the petitioner, in accordance with law.
So you say that without hearing, without disposing of the representation, they have issued a further order.
My lord, my lord.
So let the order be stayed
My
in
lord.
disposal of the
My lord.
representation.
That is my
Not-
humble submission.
Let the order not be given effect to.
My lord.
Affidavit of service. None appears for the respondents despite service. The petitioner is aggrieved by the fact that though this court, by an order passed on March 1, 2023, in WPA 25775 of 2022, directed the respondents concerned respondent to dispose of the representation submitted by the petitioner dated 30th August 2021 within 1 month from the date of communication of the order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law, no notice of hearing has been served upon the petitioner till date. Thereby indicating that the representation has not been taken up for consideration by the authority in compliance with the order of the court. Paragraph, learned counsel for the petitioner submits that without considering the representation pending before the authority, the concerned authority has issued an order on 20th April 2023, according sanction under commercial segment with certain stipulations. Stop. The said order is assailed in the writ petition. Paragraph. Upon consideration of the submission made on behalf of the petitioner and material on record, this court is of the view that since there was a direction upon the concerned authority to consider and dispose of the representation submitted by the petitioner within a stipulated time frame upon granting reasonable opportunity of hearing to the petitioner, the authority could not have passed the order impugned without considering the representation in compliance with the earlier order of this court. Paragraph, in view of the above, the order impugned passed on, order impugned dated 20th April 2023 is stayed. Paragraph, the concerned authority being the respondent number 2.
2, my lord.
The second respondent here in comma is directed to comply with the order passed by this court
March 1, my lord.
on March 1, 2023 in WPA 25775 of 2022 and consider and dispose of the representation submitted by the petitioner dated 30th August 2021 within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, since the respondents are not represented, comma, the petitioner is directed to serve copy of the representation along with a copy of this order as well as the order dated March 1, 2023, passed in WPA 25775 of 2022 upon the second respondent at the earliest. Disposed of, which are
Grateful, my lord.
next.
Grateful.
211.
I'm for the petitioner. I'm happy.
The petitioner are the existing operator in respect of route number 39A/2, my lord. And if your lordship kindly come to page 25, this is the permit of the petitioner, my lord, petitioner number 1, and thereafter I have also given the permit of other petitioners also. They are operating in the route alignment that is 39A/2, Picnic Garden Road to Howrah Station. That was very much indicated in the said permit, my lord. And all those permits were issued in 2015. And it was subsequently renewed, my lord. And if your lordship kindly come to page 30, that is the notification issued by the Transport Department, Government of West Bengal, my lord, wherein the number of stage carriages in respect of the said route was fixed. Page 30, my lord, that is the notification, and relevant portion is at page 32, my lord, serial number 62. Page 32, serial number 62, my lord.
Yes.
39 is the route number, and thereafter the Picnic Garden to Howrah Station, minor 18 is the permit strength. That is the 18 number of permits, maximum limits was given by the Transport Department. And thereafter in page number 34, my lord, I have given the fare chart issued by the concerned authority, my lord, which was subsequently issued in 2012, 14, 16, and thereafter. Now, my lord, what happened in March 2023, my lord, they were restrained by the police authority that you cannot ply in the alignment from Howrah Station to Picnic Garden because that route has already been extended. So we asked to the authority, my lord, what happened. Now we came to know from the department, my lord, in 2006, there was a representation for extension of our route. That is at page 37. I have given the entire history of the set because it has a checkered history, my lord. Page 37, annexure P4. This is the representation that was submitted in 18 September 2006, my lord, the Didin General Secretary of the route. And they have prayed for the extension of route up to Bhojerhat, my lord. That was the representation before the authority. And there was a direction of the court also, my lord. This honorable court was pleased to pass an order that is at page 42. Page 42, my lord. The order is at page 42 because one writ petition was moved. And this honorable court was pleased to pass this order. I do not think it would be unreasonable to require the Regional Transport Authority, Kolkata, to consider the prayer and pass a rescind order within 6 weeks from the date of communication of the same to the petitioners. So, my lord, the petition was disposed of, and thereafter, my lord, the Regional Transport Authority, Kolkata, my lord, they have decided the issue and considered the same that the extension can be made subject to approval by the Regional Transport Authority, South Chobbish Pargana, because the part of the route falls within the domain of that Regional Transport Authority, South Chobbish Pargana, my lord. And lordship, kindly come to page 43. Annexure P5. That is the communication made by the Secretary Regional Transport Authority Kolkata to the Regional Transport Authority South 24 Parganas, my lord, in pursuance with the order dated 7th December 2006 passed by the Honorable Mr. Justice Sanjeev Banerjee High Court Calcutta in ASC number such and such, RTA Kolkata have heard and considered the prayer of the petitioner and is willing to grant extension of route number 39A by 2 from Bhojerhat to Howrah station via such and such, my lord. And the route will cover about 15 kilometers, which falls within the jurisdiction of RTA South 24 Parganas. The above prayer of extension will be allowed subject to obtaining no objection certificate from your end. And thereafter, my lord, you kindly come to page 46. Page 46 is the letter issued by the Secretary Regional Transport Authority South 24 Parganas, and they have given the no objection as the route was approved by the RTA board on 9th July 2009. And thereafter, my lord, the route was endorsed in the permit, my lord. So far as my understanding is concerned, although we have granted permit in 2015, there was no endorsement that you have to fly up to Bhojerhat. But in 2010, there was an endorsement that is at page 47. I have given the typed copy also, page 47A.
But this was given in 2009.
This was given in 2009, but
15, it was not implemented.
it was not implemented. Now, all on a sudden, they are asking us to go before the Bhojerhat. And thereafter, I will show lordship that the decision is illegal because of the fact, because of the recent notification that was issued in 2004, my lord, that no new route can be formulated from Howrah station because of restriction issued by this honorable court, my lord. I will show to your lordship. And I have type copy as page 47A. The extension of there was the endorsement, lordship, in the permit, extension of the alignment of route number 39A by 2 up to Bhojerhat, subject to the necessary approval from the Transport Department as per decision of the RTA Kolkata dated 9th February 2010. Therefore, on 9th February, the decision was taken for extension of route.
Yes.
And if your lordship kindly allow me, although I have annexed the copy of the permit, it was not very much illegible, lordship. This is the copy of the Xerox, color Xerox of the permit. It was indicated in the said permit that it was indicated in the permit, last line, lordship, handwritten, extension of the alignment of route number 39A by 2 up to Bhojerhat, subject to necessary and approval from the Transport Department as per decision of the RTA Kolkata dated 9th February 2010. That was indicated in the permit. And that endorsement was made on 17th August 2010. There was a signature on the right hand side of the said. Yes, madam. Now, immediately after coming to know about the said extension that was done prior to our issuance of permit in our favor, we raised an objection. That is at page 49. And that was received by the concerned authority. And in terms of that, one hearing was given, my lord. We raised the objection that the resolution which was adopted in earlier, that was not indicated in our permit, we were granted in 2015. And so you cannot ask us to go that Bhojerhat point, and that particular resolution, that particular representation was considered in 2000 in the board meeting dated 12th April 2023. Lordship, kindly come to the hearing notice, that is at page 43. Page 53, Lordship, Annexure P9, sorry. And in the said meeting, we came to know that some other operators of others route, they were also raised objection. It is obvious that since there was a resolution, so we have to go before the approved route. And the resolution is at page 61. Page 61 is the resolution of 12th April 2023 board meeting. Lordship, the resolution is that President oblique secretary of route number is 128/1 and route number 39A/2 appeared before the RTA board meeting and they were duly heard. RTA board discussed the matter and decided to issue notice from Secretary RTA Kolkata within 7 days to the permit holders of route number 39A/2 for endorsement of the existing route alignment. There was that decision which was granted, taken in 2009, rather in 2010, the 2nd February 2010, my lord, that was going to implemented in 2023. Although the grant was made in our favor in 2015. And challenge in the instant writ application, my lord, the decision which was adopted in 2023 in 12th April board meeting, my lord. Now, my lord, in my respectful submission, this particular resolution which was adopted in 2010, that was not in accordance with law. Because if your lordship kindly come to the decision, lordship kindly come to page 36, that is the 36, that is the fair table of our route, which indicates the alignment of our route. It shows that we have to fly from Picnic Gardens to Howrah station. And there is one point, lordship, from the top, that Kohinoor market. And thereafter, Dorga Road and 4 bridge crossing. So, my lord, by way of extension, what they are trying to curtail that Kohinoor point to Picnic Garden, and they are trying to extend from Dorga Road to Bhojerhat, because that is appeared from the resolution. That should kindly come to page 43.
Here the extension is not shown.
Although we have asked for the extension, but what the authority has done, they have curtailed a portion of route and now they are extended, which calls the deviation of route, rather variation of route, my lord. In case of variation, my lord, the termini shall not be altered. But in our case, what they are trying to do, they are altering our termini, which is against the Motor Vehicles Act. Section 80, subsection 3 of the Motor Vehicles Act says that in case of variation, the termini cannot be altered. So, my lord, lordship, if your lordship kindly come to page 43, what the authority has decided, they have considered the prayer of the petitioner. I am placing page 43. They have considered the prayer of the petitioner and willing to grant extension of the route 39A/2 from Bhojerhat to Howrah station via Leather Complex, Bashanti Road. These points are not in our route, my lord. Science City, bridge number 4, Park Circus, Moulali, Shialda, MG Road instead of VIP Bazaar to Howrah station. So our route is completely different, my lord. In terms of this resolution, they are trying to change our route, which is not at all permissible, because this change of route amounts to creation of new route. And in terms of second Daga's notification, which I have also annexed in the said writ petition, if your lordship kindly come to the last annexure, that is annexure P13.
I think the state has to come back with a report in this matter.
Yes, ma'am. Yes.
Explaining the entire situation. Extension was allowed in 2009.
207.
Yes,
207 extension.
2007.
2007. When you issue permit in 2015, you do not include the extended part. Suddenly you come and say that it has
already, there are 18 numbers of buses there. Out of 18, 12 number of permit holders has already endorsed their permit. Already endorsed their permit.
Then
And
the
after obtaining no objection from the other authorities, other RTA lordship sees that, then my lord, RTA Kolkata has granted this.
that is in case of other operators. But in case of these petitioners, when you grant the permit,
Whether he has obtained this permit or not, but 18 number total out of 18, my specific instruction, my lord, 12 number already, my lord.
route was extended prior to granting permit to the petitioners.
Prior to
That
granting
extended
permit,
route was not included in the permit of the
that is
petitioners.
somehow mistake or like that.
There should be come back.
There
with a report. Will you come back with a report in that
Yes,
case?
because another point is that item now 218 serial number. My lord, it is the same thing happened, my lord. They challenging their illegal operating the vehicle of 39A.
That's a different issue, my lord. Their prayer has already been considered in the board meeting.
Route number 128/1.
We'll deal with that separately.
My lord,
Please come back with a report in this.
my lord.
That was considered in the board meeting. I have shown to your lordship that precedent of route number S21/1 and 39A/2 both appeared, and accordingly the decision was passed. I have challenged that decision. Now they don't have any grievance.
No, they have given. দেখা যাচ্ছে 128 তুই আছিস
128 আমি নেই স্যার, এখনো পর্যন্ত কপি সার্ভিস করেছি কিনা জানি না।
218 সিরিয়াল নাম্বার
হ্যাঁ বলেছিল, কিন্তু কপি তো দেয়নি।
এসছে বলেছে, দেখলাম যে দুটোই প্রায় এক।
দুটো এক নয় স্যার, এটা আলাদা।
এটা বলছে
You have challenged the resolution.
2007 resolution here challenge that now.
Yes, in 2015 when
Even 2015.
when the grant
That is
was
an 8
made,
years.
that was not
8 years
intimated
back.
to us that your route has already been changed. You have to apply in a separate route. Although in terms of gazette notification, we were allowed to apply from Howrah station to Picnic Garden. And no such transport department approval was taken by the transport authority, my lord.
Anomalies in the different orders.
Gazette notification also indicate the authority can modify or alter or anything like that.
Yes, my lord.
Not without hearing.
And so far as
Petitioners have to be
so far as the
given an opportunity of hearing. Isn't it?
resolution is concerned, my lord, it says that you have to take
2007,
approval from the
2000.
transport department. Till date, no approval of the transport department was taken. It was indicated in the permit that subject to approval of the transport department. Let them produce any approval from the transport department.
After 10 years, my lord, petitioner enjoying benefit, then my lord coming.
Yes, in 2015, you have granted permit from
When
Howrah station to
when joint
Picnic
meeting
Garden.
was held, 1 minute, pass karo. Joint meeting was held on 12th April 2023. Both are agreed.
No, but we are not agreed, my lord. I personally appeared. I raised our objection that we will challenge the same. And thereafter authority says, yes, you can challenge in before the appropriate forum. That is up to you. We are not at all agreed. Agreed, my lord.
Mr. Debra, please come back with a report
My lord.
indicating all the details. Because there, prima facie, there appears to be some anomalies. The decision taken by the respondents in the meeting dated 9th February 2010 regarding change of alignment of route number 39A/2 and the subsequent decision taken on 12th April 2023 are under challenge in the writ petition. These two decisions are challenged.
Yes, yes.
Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph, let the matter appear under the same heading on 28th August 28. You can take back this.
Yes.
Affidavit of service sheet. Please clarify the stand of the authority.
I am annex all the relevant documents.
Please, please.
So that matter can be.
212.
I beg to blur, sir. But in this matter, I am appearing on behalf of the petitioner.
I am appearing for private respondent led by Mr. Senior.
I am appearing, my lord.
I have served the copy upon the private respondents. Served is ready. Well, here in this case, the interstate route, my lord, I have served the copy to all the respondents, including state of Jharkhand also.
Yes.
Well, kindly see the page number 32. Well, I am holding a permanent stage case permit on interstate route. Page number 32. My lord has got it. Page number 32.
Yes, yes.
My lord, serial number 8. When initially, my lord, permanent permit on interstate route was issued by the state of West Bengal on the route now Diha to Tata via Kushro, Kenamod, Chas, Purulia. And at the bottom, my lord, last right side at the bottom, my route was curtailed from Naudi to Fusru and extended up to Gumia from Fusru. After curtailment extension, the route is Gumia to Tata. Yes. Now, kindly timetable the conditional permit. That timetable was issued by the state of West Bengal. Page number 34.
Yes.
At the bottom, let's have it, they extended up to 7th August 2026, till the validity of the permit. Now can you see the page number 5. I have another
Five?
permit,
35.
35. I have another permit from Durgapur to Jamshedpur via Durgapur barrage, Bankura, Purulia. And this permit also valid till 2027, 31st October 2027.
Yes.
And also timetable page number 36. This timetable also provisionally approved till the validity of permit.
Yes.
Now, my lord, allocation, my lord, annexure P2, there are two timetable. I have the two permit, two timetable. The dispute, my lord, down trip from Tata, my departure time, my lord, 140, the permit which is flying on the road, Gumia to Tata. Page number 37, 1:40 p.m. And another permit,
Page number 37.
yes, page number 37, my lord, the down trip, departure time 1:40 from Tata. Top, left side, the right side. Next page, page number 38,
Departure from Tata, arrival is
140. My page number 37, route arrival, departure, Tata 1:40
there.
departure.
1:40 p.m.
Yes. Next page, page number 38. Here also departure time from Jamshedpur, that will start the same place, 1:35.
This
This-
is 1:35.
Yes, ma'am, yes. Now, my lord, my allegation against the, my lord, is number 7. Kindly see the page number 39.
Yes.
One permit, my permit has been issued by the State Transport Tribunal from the quota. Now, my lord, allegation against my lord is number 7, that is Bharat Chandra Sharma. His permit was issued by the state of Jharkhand. His permit was issued on the Chaibasa to Bokaro. Now I'm reading, ma'am. And the permanent in the stage carriage permit, PSTB number such and such, issued with vehicle number J09Q3651, granted in favor of Sri Bharat Chandra Sharma by the State Transport Jharkhand and valid for the period from 8 October 2016 to 17 October 2021 on the route from Bokaro to Chaibasa via Purulia. Tata is hereby countersigned for the portion of the route falling to the state of West Bengal. Now, my lord, middle portion, this is the timetable. These timetable, these are valid, old timetable, old permit. Initially, this permit was issued in the year 86. Since 86, the middle portion which timetable has been quoted, this timetable was issued so when the first permit was issued, that timetable was continued till, my lord, 7th October 2021, till the validity of permit. But their departure time, in middle portion on the left side, Tata 3:30 p.m. departure.
Yes.
Because the difference with my timetable, more than 130 minutes. So there is no problem. I never raised the objection. Now can you see the next page, page number 40. Relevant portion, my lord, page number 44. Private respondent, that is Bharat Kumar Sharma, he did not ply the vehicle last 5 years due to non-payment of the tax, because section 12 of the West Bengal Motor Vehicle Tax Act, well, permit is invalid due to non-payment of the tax. So, well, he did not ply the vehicle. Now, my lord, before expiry of the permit, he made an application for renewal of permit and also submitted a proposed timetable, page number 44. He submitted proposed timetable. That is top, this is a proposed timetable, page number 44. And next paragraph, that is the notice was issued by the state of Jharkhand, inviting objection within 7 days. Hindi version, some middle portion. Appeal 7 dinons ke andar. That means within the 7 days, the objections, if there is any objection against this proposed timetable, then other existing operator or any person can make the objections, So, pursuant to this notice, I raise this objection, page number 40.
Page number?
40, because I have enclosed this notice for this reason, my lord, I have shown as first at this 44, then 40. 40, my lord, this is the objection. Objection invited, my lord, issued on 20th September 2021, and within 7 days, objection must be submitted. Then, my lord, notice was issued 20th September. There I, my lord, submitted, I submitted the objection at the bottom left side, submitted on 24th September 2021, received by the state of Jharkhand. At the bottom, my lord, right side. Yes. What is my objection? On the second paragraph, I have said so that the Bharat Chandra Sharma, despite holding permit in the interstate road in between Bokaro to Chaibasa, did not operate his state for the last 5 years, and tax the state West Bengal has not been paid. The permit issued in favor of Bharat Chandra Sharma has become invalid in terms of Section 12 of the Motor Vehicle Tax Act 1970. This is the one of the conditions. Therefore, objection is not required to be read, my lord. Only I submitted on the relevant portion. Well, then, my lord, clause number D, page number 41, D, Bharat Chandra Sharma is having his timetable for departing his vehicle from Tata Point at 3:30 p.m. since the issuance of the permit in his favor, and same has been countersigned by the ST West Bengal through Sri Sharma has not been operating his vehicle for a long time, and that can be ascertained by the authority after making an inquiry through the motor vehicles inspector. The next page, my lord, what is the relevancy? Last paragraph, page number 41, last paragraph F. As my timetable has become a stable timetable for following the same during the course of operation of his vehicle, as approved and countersigned by the authorities, Bharat Chandra Sharma has made an attempt to create a chaos and disharmony for placing his vehicle just 10 minutes before the departure of my vehicle in the route Gumia to Tata, and in case Durgapur to Jamshedpur route just 5 minutes before the departure of my vehicle. Be it mentioned here, in the case of Gumia to Tata route, the alignment of 140 kilometers is common with the Chaibasa to Bokaro route, and similarly, the said Chaibasa to Bokaro route is having a common alignment of 90 kilometers with the Durgapur to Jamshedpur route. I submit that the common alignment of the said two routes is a very vital part for making the route economically viable, and in case of revision or variation of the timetable of Bharat Chandra Sharma by overruling my objection as submitted hereby, the economic viability of my two routes like Gumia to Tata and Durgapur to Jamshedpur would be seriously affected, and jeopardize economic viability nowadays is very relevant consideration for operation of vehicle in the interstate road by serving the traveling public, by making investment which has become too high, and unless the route is economically viable, monthly installments to the financer cannot be set. Now, my lord, after G, that is middle portion, in view of above, I pray you will be kind enough to consider my objection in its proper perspective, and by rejecting the prayer of Bharat Chandra Sharma for revision and variation of his timetable as prayed for. But earlier timetable 3:30 departure for Sharma. Now, in the proposed timetable, kindly come back, page number 44. That is, departure timetable has been shown here, Tata 1:30. That means my one vehicle, that is Jamshedpur to Durgapur, my departure 1:35, that means just after 5 minutes. And also, so what the Gumia to Tata, that is 1:40, my departure time. That means 5 minutes and 10 minutes only gap there. Normally, I made the objection before this, because the objection invited within 7 days. I have submitted objection within 7 days. And there were a copy of the also another objection, the same objection also submitted before the State Transport of West Bengal, page number 51. Because it's a counter signing authority. West Bengal, State West Bengal is a counter signing authority. So I have to, because same time it will be same to the authority, West Bengal, for counter sign. For this reason, I have made page number 51. Page number 51. Now kindly say, well, I'm making my submission in the cut short manner. So my lord, kindly say the page number 68. Page number 68.
Yes.
On the state of Jharkhand, the State Transport Authority Jharkhand renewed the permit in favor of this Bharat Chandra Sharma without considering my objection. because the objection was invited within 7 days, so I submitted that. The permit was renewed on next page, page number 69, 11 January 2022. 69, this is the signature, date of renewal of the permit with effect from 8th October 2021 to 7th October 2026, so 5 years. Against the vehicle number 12A J09Q3651. And page number 70, this is the proposed timetable which was approved without considering my objection, keeping the pending objection of mine. So keeping the pending of my objection, this proposed timetable was approved, same proposed time. Can you see the proposed timetable, page number 44? And also which was approved for 2 months. This is the same timetable, has not been changed. Even after receiving, say after approval this timetable and after issue a renewal of permit, the next page, page number 71, the Secretary State Transport Authority Jharkhand Ranchi inform the Secretary State Transport Authority West Bengal, via memo number such as dated 12 January 2022, requesting to countersign on the permit as well as the timetable. Has got it, my lord?
Yes, 71.
As I have already submitted the objection before the State Transport Authority West Bengal also. So before counter signature, State Transport Secretary State Transport West Bengal informed me, page number 74, to appear for hearing before the Secretary for hearing the objection, because which are submitted long back. Page number 74. White memo number such and such dated 7 June 2022. Secretary STA informed me to appear on 21st June 2022, and also informed to Bharat Chandra Sharma also at the bottom, Bharat Chandra Sharma also, both petitioner, objector and also objective, both. Now I appear before the Secretary STA, and no decision was communicated. Before that, my lord, I submitted one application. Then on the same issue, page number 76, on the same issue, before renewal and also proposed timetable, on the issue of proposed timetable, objection was invited. And in that case, my lord, I also submitted the objection. After hearing both sides, timetable was reverted, page number 77. Under the above circumstance, it is hereby ordered to revert the modified timetable to the respondent, Sri Ashish Kumar Goswami. So I requested the authority at the time of hearing, so same procedure can be adopted in my case also. Now, kind of say, but decision was not communicated. Then I made a representation, page number 78, requesting the authority to communicate the decision. So long the decision is not communicated, the request is not to countersign. Page number 78. NHRP 11. Page number 78. And also I enclosed inter documents that the renewal of permit of the form number 7, and also, my lord, the memo which was submitted before the State Transport account for counter signature. After receiving that representation, due to non-conscience of that representation, I moved the writ petition before this honorable court. Page number 85. Page number 85.
Yes.
But this application, this writ petition was disposed of by your lordship on the simple, because the very simple matter, because decision was not communicated. So my lord directed the authority to communicate the decision, nothing else, only the simple order. Pursuant to the direction of this honorable court, page number 87, a decision was communicated. That I have challenged this resolution also, in this decision also in this writ petition. Well, I raised 2 issues at the time of hearing before the Secretary, State Transport Authority, the learned advocate, Mr. Samanta, pleaded that tax has not been paid in favor of objector's vehicle. Because why he not ply the vehicle last 5 years? That is, tax was not paid. The objective vehicle was not plying for 4 years. 4 years he not plying the vehicle. But what is the law? According to section 72 of the Motor Vehicles Act, the vehicle shall be used on a specified area, which was mentioned in the permit. Subsection 72, subsection 1B, operation of the vehicle shall be commenced from the date of assigned in the permit. There is a violation, permit liable to be cancelled under section 86 of the Motor Vehicles Act. But that has not been examined. I raised this point at the time of hearing when the issue came for settle the issue on the issue of timetable. And another objection, my objective timetable was not extended after 2 months. Proposed time was granted only for 2 months. Second, there is time gap of 5 minutes between objector's vehicle and objector's vehicle. 5 minutes one vehicle, 10 minutes one vehicle, that isn't recorded. That is the decision, can you see? The objector lost objection on 29 September 2021 when there was no scope for renewal. But absolutely, my lord, don't application of mine. Why I made the objection on 29 September? Because 20 September, my lord, objection was invited. Because proposed tribunal was submitted and objection party within 7 days. Within 7 days, I submitted objection. So I'm not from my side, my lord, I read the objection because they objection invited. I objection. When there is no scope of renewal, how they will renewal? Unless the, my lord, the objection is invited, accepted, thereby to place your hearing, then authority will decide it. The permit was renewed by this authority, by the state of Jharkhand on 11th January 2022. That has not been recorded. Nothing actually cryptic in manner. There is no factual case that's been discussed in this resolution. Only simple 5 minutes timetable is not the relevant. When there is no scope of renewal and countersignature of the objective permit, the objective permit was renewed later on, 12 January 2012. And permit holder applied for countersign on 16 December 2020. But before renewal of permit, countersign part, he is a part of the granting authority. He should raise before the State Transport Jharkhand the objection. When the objection was invited, it is a mandatory duty to consider that objection. Thereafter, permit should be required to be renewed. This is the law. Because my God, I have served the my lord last 22 years, my lord, in the state of West Bengal on the my lord interstate route. So many I have contested my lord appear on behalf of the petitioner. Mr. Deprai, my lord, on that time, my lord. So my lord, this is the procedure. That procedure has not been honored. না না প্রশ্ন নয় ম্যাটার গুলো দাঁড়াতেন আমি আরে অন্তর্কাশ দিতে হবে শাব্দিক দাঁড়া তো only my lord there 5 minutes gap nowadays when only on this issue my lord only settle because in this objection my lord I am so many point they have taken that is I've already the tax has not paid last 5 years vehicle was not flying for 4 years why has not they said that should be answered by the permit holder before the renewal of the permit. That is not only my objection has been rejected on the sole ground that the nowadays 5 minutes that is not the relevant, it's not the significant nowadays when the permits are being issued in liberalist policy. This is the interstate route. It is not the free route. Time quota has been fixed. But in this Tata to Bokaro, only 5 vehicles are plying on the route. Each and every gap vehicle, 35 minutes gap, 40 minutes gap, 50 minutes. So far, in my case with Bharat Sharma, only 5 minutes, 10 minutes gap. Now, my look, I have discovered another thing. Kindly see the page number 88. Very important.
Number 80.
88, page number 88. 88, page number 88.
Yes.
But one permit on the road, Purulia, Bokaro to Purulia was issued in favor of this Bharat Sharma by the State Transport Jharkhand in the year, my lord, permit number, my lord, 01/1978. It's the old permit also. Page number, serial number 11. The validity of permit for 10th March 2020, it was continuous process. It was time to time renewal. Last permit was renewed up to 26th. The date of renewal of 10th March 2023 to 9th March 2028. Registration mark JH09BB1390. Only the permit is countersigned. This permit not valid to the other agent. After grant of renewal of the permit, State Council of West Bengal in Jharkhand, page number 91. Page number 91. Secretary State STA Jharkhand requested the Secretary STA Kolkata region requested to countersign on this permit, intimating that, but I am reading that this authority had issued a permanent stage carriage permit number PSTP number 01971978W in favor of Sri Bharat Chandra Sharma for the intrastate route Bokaro Steel City to Purulia via charge on vehicle number J09J3651 200 model valid up to 9th March 2023. Now kindly see back, my lord, page number. Page number 68. Page number 68.
Yes.
This permit, Bokaro to Ranchi, Bokaro to Purulia, this permit was renewed on 10th March 2023. This was done, Amar Bola session. About this memo was issued by the state of Jharkhand 10-20 January 2023, stating that the vehicle number J09J3651 was valid till 9th March 2023 in the route which is plying Bokaro Steel City to Purulia, PSTP number 01978. On that period, J09Q3861, which was endorsed in the permit 8-10-2021 to 26. One same vehicle, showing the same vehicle. The permit has been obtained. Two vehicle, one vehicle has endorsed in two permits. What is the law? If a vehicle will be applied on the specified route, which is mentioned, one permit, one vehicle. That is the law. At the same time, for this reason, my lord, he has stopped applying the vehicle because that vehicle was already endorsed in the permit number 1, which is plying on the route Bokaro State to Purulia. It is very clear. That has not examined how this permit was renewed on the route, my lord, Jharkhand to Chaibasa to Bokaro. At the same time, my lord, that vehicle was endorsed in the route Bokaro still to Purulia. My lord, a relevant, my lord, objection, a serious objection was made. Not only dispute of timetable, there is other objection there that has not come at all. Only, my lord, issue of timetable, they decided and requested the authority to countersign the permit. Now kindly see page number 93. I made a minor objection to make this inquiry for cancellation of permit PST number page of 93. I made the representative before the Secretary State Transport of West Bengal and State Joint Transport Commissioner Government of Jharkhand both. Cancellation of permit PST number vehicles such as such route Chaibasa to Bokaro. With reference to the above, I Om Prakash Gupta is very old and bona fide operator on the route now near to Tata, extension up to Gumia via Fusro, Jonamore, Charles, Bokaro, Purulia as well have been plying my respective vehicles such and such on interstate road permit duly issued by State West Bengal and countersigned by State Jharkhand in terms of interstate distributed transport agreement back to state as follows. Mr. Bharat Chandra Sharma, owner of vehicle number such and such and permit number such and such on the route Chaibasa to Bokaro via Tata, Purulia has not been plying the vehicle on the mentioned route for over 5 months. The fitness of the vehicle endorsing JSQ9Q3651 is also expired. However, he is plying another vehicle with number 1390 and does not have the permit to ply the same Chaibasa to Bokaro state. My lord, this vehicle, that is vehicle number 3651 endorsed in the permit, which is plying Chaibasa to well. But that vehicle is plying, displaying the board Chaibasa to Bokaro. My lord, with my lord registration number plate 1390, or that vehicle is endorsed in the permit which is plying Bokaro to Purulia. 1390 vehicle is endorsed, and see the page number 38. Validity of permit and particulars of registration number 1390. 1390.
Yes.
1390. Now kindly see the page number 95. STH Jharkhand requested the Secretary STH Jharkhand for extension of timetable on route PSTB number in favor of PSTB number 15. When requested now 23rd August 2022. But at that time, this vehicle was 365161. This vehicle is attached with the permit which is plying Bokaro to Purulia. Next page. Page number 96.
96.
96. Timetable improved till the validity of permit. Yes. Next page, page number 97.
This is provisional.
Yes, yes. Provisional. Now, my lord, why this vehicle is not plying 3651? Because as per my lord, particulars of the vehicle, page number 103.
103.
103. I collected from the website vehicle number 139. Sorry, 102. Sorry, 102. At the bottom, my lords, just after 4 line, fitness valid up to 12th April 2023. No vehicle can fly without fitness certificate. For this reason, my lord, displaying the board, I've given the photograph. Can you see the page of photograph? Page number 111, 12. Displaying the board Bokaro, say from Bokaro to Purulia at the Chaibasa, sorry, Bokaro, say Chaibasa, then Purulia. At the bottom, my lord, J09 BB1390. Whether but this vehicle is endorsed in the permit which is flying Purulia to Bokaro, PST number separate. And Chaibasa to Purulia is the vehicle number 3651. That is proof from the photograph. So all this representation kindly direct the authority to stop the flying of the vehicle at first. Throughout inquiry is required to be placed, which was my objection. And also at the same time, 2 vehicles attached on the 2 permit, and the one same vehicle attached within the 2 permits. Because law says, my lord, that is not permission under the law. That is not verified inquiry, nothing else. And also, my lord, another representation was made for my protection. It is my duty, my legitimate demand. Page number 100, last,
Actual aspects.
only one lecture I'm showing. Page number 106. For my protection, that I have also, my lord, submitted a proposal that next page, page number 107. B. Total 6 vehicles are flying on this road. Ma Parvati, Kullani, Ma Shankari, these are the vehicles name. That first, my lord, departure time from Tata 140. Second vehicle, my lord, departure time 12:15. That is here 55 minutes gap. Next, Ma Shankari, departure time 15. Next, Bharat Chandra Sharma 130. That is the response 7. There 25 minutes gap. Departure time 130 from Tata of response number 7. Then My vehicle, 140, we just start from
minutes.
Tata to Gumia, 140, 10 minutes gap. And also another, my lord, which has not been mentioned here, that is Jamshedpur, Durgapur, Jamshedpur, 135 departure time. And the next, my lord, 144, that then, to have 50 minutes gap, Songpuri permit. In my case, only 5 minutes and 10 minutes gap. So what is why I keep the proposal last paragraph? In such circumstances, it is my humble request to your goods office to kindly look into the aforesaid matter and further be pleased to propose a different timetable, example 440 instead of my lord 130 of response number 7, that can be 12:45 p.m. or 1:25 or 1:55 p.m. But that after consideration, after hearing. Well, there, before that, my lord, I have also one representation also, page number 93. Both be considered at a time. And after hearing both parties. Now my prayer, my lord, magnanimous prayer. Page number 27.
Yes.
Read in the nature of magnanimous commending the respondent authority to so as to why. Memo dated 23rd August 2022, bearing revision of the timetable, that is the decision of the ST West Bengal, which was taken on 20, bearing revision of timetable of the private respondent in respect of his private being decision dated 21 June 2022, taken by the Secretary ST West Bengal, and the affecting the counter signature in respect of vehicle of the private respondent by the Secretary ST West Bengal was first so that the consultation. The same prayer also second when interim order setting aside there. At interim order D, at interim order setting aside the memo dated such bearing revision of timetable of the private respondent in respect of his permit being PSTB number. The impugn decision dated 21st June 2022 taken by the Secretary ST West Bengal, and the affecting of the counter signature in respect of the vehicle of the private respondent or the Secretary with the direction to respondent authority to court withdraw the timetable of the private respondent. Same thing. That is my submission.
Yes.
Was private respondent? No, myself. Regarding consideration of the timetable is concerned, I have no objection at all. Regarding my lord, next my lord, question regarding one vehicle, 2 permit cover, that is the allegation raised by the raised by the Mr. Khan's client, Mr. Khan's, that has to be incurred into, because that cannot be permissible in the eye of law.
You want to come back with a report?
If your lordship permit, my lord, that is better.
Let him come back, stating.
I am for the private respondents. My permit and timetable has been challenged in this writ petition. But I fail to understand what I really prayed for in this writ petition. Initially, the dispute relating to a timetable has been decided by the authority pursuant to your lordship's order. That order was passed sometimes in the May 2022, January 2022. Thereafter, this writ petition has been filed just 1.5 years after that decision. First objection. Next, my lord, what dispute relating to a timetable has been merged with the dispute relating to the ply of vehicle. That how it can be possible in one writ petition. Let him decide first what is their objection, because your lordship have seen.
In fact, I was minded to call for affidavits in this matter. There were several factual disputes.
No, my lord, your lordship kindly have looked the last.
The permit by practicing thought.
Your lordship kindly have a look the last representation. What relief he has paid for? Only dispute is to timetable. And so far, Rule 119 is concerned, my lord, the decision of the authority is the final. That has been decided. Same dispute, my lord, same objection regarding 5 minutes.
Will you
They
come
are
back?
availing 5 minutes gap.
Will you come back with short affidavits?
Well, both the replay may be considered by the authority after hearing both parties. That will solve. That will let the authority. it has been mistaken that will be rectified by the same authority. So after hearing true representation, but the authority, nothing else. Then it is left to the authority because that part has not been considered. For this reason, I made that result. After hearing both parties, that will be clear.
One thing is only timetable is concerned, my lord. Mr. Bhattacharya correctly said, my lord, he has not, in a prior portion, there is not allegation against, the allegation against two permit or one victim. That is not in the prior. That is to, my lord, Mr. Khan raised another point. Yeah, my lord, only lordship can direct, only lordship can direct the authority to consider the objection, objection.
Election number 11, 16.
14 January 2023.
Yes.
It has been decided in the earlier occasion.
That has
5 minutes
No,
gap
no,
is
no.
a sufficient time.
No,
That time there is no pressure.
if
because-
he's agreed, my lord, that
If there is any,
that has
we
to
will
be
consider a representation, your lordship. That will be the.
that has to be considered by the authority.
That initially the permit issuing authority by Jharkhand. They, he is the operator of West Bengal. Against the timetable issued by the state Jharkhand, they made objection. He made objection.
That without considering objection.
That objection has been dismissed and rejected. And suppressing the material facts by the earlier representation. People, after making a representation before the West Bengal, that representation has been considered and decided by the authority, pursuant to your lordship's order. After 1.5 years, by the they came forward with another objection to certain dispute.
For misguiding the court because objections are invited by the state Jharkhand. But without considering objection Jharkhand, that is it.
You continue with the.
Well,
hearing
kindly
on
see
some
the page
other
number
date.
106.
30.
That debate can be considered. And page number 106.
Past 3:30, the hearing matter.
Yes.
Taken up.
Kindly
Please
see
come.
the next step. Yes.
That will be continued tomorrow. Tomorrow it will be continued. Tomorrow not possible. Come back after in August.
Well, short date, well, because
Her learned counsels, affidavit of service denied, her learned counsels for the parties. Paragraph of the matter appear under the same heading for further consideration. 22nd August.
10 years.
That-
It's your organ. Till last night.
Item 45 fixed at 3:30.
22nd.
Item 45 fixed at 3:30.
This was my repetition, lordship, since a lot of time has passed. I had made my submission, but I will take just 2 minutes to recapitulate and I will come and rejoin.
Are the respondents?
Yes, respondents.
I'll just find out. You do not know.
I asked him, he told me it will take 1 hour time.
Because we are very, we are in a, I will tell lordship, what is our urgency? Lordship? This is a case,
Shall I release the other matters?
kindly do that, my lord.
This will take some time.
Yes, this will take time.
Vidhi, other
Because I had
matters-
argued for,
Other matters released for the day. Other matter released for the day.
because I had argued for. I had completed, I am saying I had completed, but just to recapitulate and why I be mentioned so many times for listing, this is a case of a license of a land to be followed by a very long-term lease, 99 plus 99 plus 99. This was given in the year 2008, and there was a covenant there that we have to commence construction within a certain, I think within 2 years, no? Within 3 years. Within 3 years thereafter, we had to commence construction. Now, this was from March 2008. No, 24 months, 2 years, because some cases they put 3 years, some cases they put 2 years. Here, this is 2 years. March 2008, admittedly, we did not commence construction other than construction of the wall and all, for which we gave notice. That is because the mutation happened in our name in June 2008, after over 1 year by KMC, and we submitted the building plan. The building plan was as is the procedure, The municipal building committee approved, but the building plan was sanctioned in June 2011. So we could not commence construction. Before that, on 21st February 2011, that is 2 years and 7-8 months after that date, they gave us a cancellation notice cancelling my allotment. Now, here, we had, before that allotment was cancelled, we had applied for extension of time. In November 2009, we had asked for extension of time within the 2-year period, though nothing much turns on it. But this cancellation notice was given, which got stayed by the High Court, and thereafter finally disposed of by Justice Talukdar in September 21, recording the fact that we had applied for extension within time, and then asking them to reconsider the cancellation. Now, this was in September 2021. And thereafter, they have reverted back by cancelling, once again, reiterating the cancellation. I had come, my lord, essentially on few grounds. One was, time is not the essence, because time, there is a provision for extension of time. And this has been interpreted by our high courts, and especially Justice Indira Banerjee, as her leadership then was, said that these property allotment cases, you cannot just cancel because it has not happened, especially when the petitioner is ready and willing. So cancellation is not the resort which is to be taken by KMDA in case of a similar 24 months case. That this is arbitrary action. This is what they were, a doctrine of proportionality was applied, and the court held that this is extremely harsh, and following the various judgments of court. Secondly, Mala, I had shown the government policy, KMDA's policy, to also give a fine and or a penalty and regularize it. There are policies, and my submission was it is discrimination. I have shown in other cases they have applied that policy and given the penalty. Of course, with a rider, I must add that in those cases, I have had the occasion to appear for the private party. The court has even struck down their levy of penalty, saying that when somebody is not intentionally delaying, you can't levy penalty on your own. But be that as it may, there is a policy which I have disclosed their policy decision, that they have the policy to award penalty and to regularize it. That's lesser of the harsh two evils. So my submission was, by citing judgments that when there are two consequences for the similar offense, the state should not recourse to the harsher offense unless there is the facts on record and they've applied their mind and found why the harsher remedy should be applied. Here, there's no application of mind to the harsher remedy of cancellation, and especially when, and this will lead me to my third point of discrimination. Other cases, they have imposed penalty. Even in the Austin distributors case, before Justice Indira Banerjee, they had imposed penalty. There was no extension of time application. Penalty was imposed, and thereafter, when penalty was not paid, it was cancelled. That case, the court struck down not only the cancellation but also the penalty. So since they are bound, after all, KMDA is bound by a judgment delivered, though not in, I am not saying res judicata, but they are bound by a decision of a court in their case. They have been saying in all the matters so far that there's an appeal pending from Justice Banerjee's order, Austin distributors, but there's at least, for sure, there is no stay and the order is still remaining. Now, our anxiety, why we are so anxious, is because the building plan was sanctioned in 2011. It got lapsed in the meantime. We filed a writ petition. The writ petition is for extension of the building plan because of no fault of ours. This has been so now, my lord, the matter keeps coming up, and the Lordship Justice Amrita Sinha rightly feels that if you can't, I can't start, because though your Lordship has stayed there, no third party rights to be created, but I can't commence construction. So, and that's fixed on the 7th of August. Of course, I will, if the hearing starts, I will show the court. Otherwise, the court feels that is becoming infructuous because of this. So this is my submission. This I'm not repeating the judgments itself. I'm grateful. Well,
First, kindly have a look to the license agreement that was executed between the parties, which your lordship would find at page 71 of the writ petition.
Yes.
This deed of license was executed on 12th March 2008 between KMDA and Bajoria Holdings. Now, please turn the page. Please take page 72, the second recital. Whereas the authority is not now in a position to grant lease of the hereinafter mentioned land in favor of the licensee. Now, please take paragraph 2 at the bottom of that page. The license under this deed shall be deemed to commence on the date of these presents, and possession shall continue to be operative till the execution and registration of the lease deed, so and so.
Yes.
Now, kindly turn the page, my lord. The fundamental clause at page 73.
Yes.
4 III.
Yes.
At the own cost of the licensee within 24 months from the date of issue of the allotment letter, or within such further time as the authority may, as its option allow, in writing, on sufficient and reasonable grounds to start construction for the purpose of setting up an outsourced management hub in East Kolkata area development project with boundary walls, sewers and drains in accordance with plan sanction specification, as shall be approved by the appropriate authorities on payment of such fees as required in accordance with the building rules of the Kolkata Municipal Corporation, with the requirement of any land use and development control regulations of the authorities, or the requirement of any other statutory rules and regulations or regulations of local or statutory body framed for the purpose, and the licensee shall complete construction of the works of the project within 36 months from the date of issue of the allotment letter. So, my lord, constructions are to be carried out within 36 months. Please turn the page at the top. Failure on the part of the licensee to start construction within 2 years or within the time as extended by the authority and or complete the construction work of the project within 3 years from the date of issue of the allotment letter of the plot of land, the license shall be terminated by the authority with deduction of etc. So, failure to construct, license can be terminated. Now, please skip over a few pages and please come to page 77.
Yes.
Paragraph 6, provided always that it is hereby further expressly agreed as follows. If there is any breach of any covenant on the licensee's part herein contained and to be performed or observed by the licensee, it shall be lawful for the authority at any time thereafter to re-enter upon the land after determining this license. So, right of re-entering is also reserved. Kindly take 6 III. Any relaxation or indulgence granted by the authority to the licensee or by the licensee to the authority shall not in any way prejudice the rights of the parties under this deed of license. These are, the salient features of the license, which requires your lordship's consideration. Now, please take page 70 now. Before this license deed was executed, possession was handed over to them at page 70.
Yes.
Handing over of permissive possession. of so-and-so land. In terms of the communication made by so-and-so and subsequent approval to this effect accorded by so-and-so, and on the basis of the drawing prepared, permissive possession of so-and-so land free from all encumbrances under so-and-so is handed over to Bajoria. My lord, 2 years expire, my lord, on 12th of March 2010. But under the conditions of the contract, my lord, constructions were to be made within that time. Now, if your lordship may kindly take, my lord, from my affidavit in opposition, a few documents. But the first document, my lord, your lordship would find, my lord, at page 37. To maintain the sequence, my lord, may I place from the affidavit in opposition? Yes. I'm sorry, my lord, page 35. Please take page 35 first.
Yes.
But this is on 22nd of April 2008. This is to inform you that the license deed has been executed between KMD and Bajoria Holdings, and possession of the plot has been handed over on 4/2/2008. As such, KMC tax and other charges of the land payable by Bajoria will be applicable from the date of possession, that is so-and-so. You may kindly take note of so-and-so. Then, my lord, skipping over page 36, please take page 37.
Yes.
I am directed to inform you that you have been called for a hearing in the chamber of so-and-so on so-and-so date with all documents like proposed building plan, project implementation schedule in the form of bar chart, mutation certificate, and photographs of the actual progress of construction. There are 3 or 4 such hearing notices made, which starts from page 37 to 42. But I'm not placing all these, my lord. These are all hearing notices issued from time to time. Then kindly, my lord, have a look to page number 43.
Yes.
But this is, my lord, a meeting, a 15th meeting of the Land and Allotment, Flat Allotment Committee. My lord, this was held on 23rd of November 2010. My lord, the date is not somehow available because thank you. No, আমার কাছে আবার
The
23rd.
meeting was held on 30th July 2020.
Very well, very well, very well, very well. Thank you. ঠিক আছে। ওই পাতাটা কোথায় গেল? কোন জায়গাটা আমাদের যে ডিসিশনটা নিলাম? Please give me a moment. ভালো হবে না? Yes. Page number 46. Agenda 11. At the top, the committee ratified the decision of cancellation of the allotment of bulk land plots allotted to Messrs. So-and-so and Bajoria Holdings. We are concerned about Bajoria Holdings. Then, my lord, we cancel it on the ground that clause 4 III has been violated. This, my lord, will find at page 51. But this is dated 21st of February 2011. With reference to the above, this is to inform you that so-and-so was allotted to so-and-so after actual measurement of such and such was delivered on so-and-so. According to the terms and conditions of the license deed, clause 4 III, Executed with you on 12/3/2008, the allotee had to start construction of the project within 24 months and complete within 36 months from the date of issue of the allotment letter. But it was found that you have neither started the construction nor requested KMDA for extension of time within the said stipulated period. This is clearly against the terms and conditions of the license deed clause number 4 III executed. During the hearing attended by you, after 4 hearing notices, you failed to submit any evidence as to the progress of the work on the allotted plot. Therefore, as per the terms and conditions enumerated in the license deed clause 6.I, the offer of allotment is hereby cancelled and possession of the land so delivered is withdrawn. License deed thus stands cancelled. Now, my lord, challenging this, my lord, a writ petition was filed, which was allowed by a coordinate bench of this honorable court. My lord will find it at, my lord, page 52. Well, instead of taking your lordship through the order in its entirety, please take, my lord, the relevant portion, my lord, at page my lord, page 58, the last paragraph.
Yes.
Having heard the parties and considering the materials placed, this court must notice at the outset that provisions of clause 4 III of the deed of license. Such provisions inter alia provide for exercise of discretion by the KMDA to allow extension of time. It therefore stands to reason that arguably in the event the disputed letter dated so-and-so would have reached the desk of KMDA, it would be within the jurisdiction of KMDA to consider whether something qualified for petitioner, qualified for grant of extension of time to complete the construction. While this court finds persuasive force in the stand taken by KMDA that the LOA and the deed had merged and therefore their terms must be conjointly considered, at the same time, this court must notice the situation prevailing qua the petitioners corresponding to the period when the communication dated 24th November 2009 was purportedly addressed to by the petitioners to the KMDA. Then, my lord, rest, my lord, I don't trouble your lordship for the present. Now, kindly skip over a few pages and please take, my lord, page 62. The first paragraph, from the paragraph supra, the petitioners claim to have committed and or invested around 3.35 crores to the OMH. In the face of such commitment on paper, now the actual situation on the ground as existing on 24th November in relation to setting up the OMH requires a detailed examination by KMDA. The KMDA shall be thereafter free to arrive at any decision on the merits after giving an opportunity of hearing. To sustain the final directions as above, the court finds succor in the interim order dated so and so. Now kindly turn the page where the matter is delegated before the authorities for a decision. First paragraph at page 63. Before parting with this discussion, it is however clarified that with the long passage of time since February 2011, when the impugned communication was addressed by KMDA to the petitioners, neither the touted economic meltdown of 2008 nor the present pandemic of 2020 can be said to be of any assistance to the petitioners, since KMDA will examine on merits the ground realities qua the OMH as existing on 24th of November 2009. To reiterate, KMDA shall be entitled to achieve at an independent decision on merits. For the above reasons, impugned communication is permanently stayed. Then, my lord, we call them for a hearing in terms of the order of the court. Now, kindly similar the order which is passed at page 65.
Yes.
But this is the order of 28th of January 2022. My lord, please turn the page. Kindly take, my lord, page 66, middle of that page. Or if I may read, my lord, subparagraph A and B above that. However, the allotee petitioner has prayed for grant stroke extension of suitable time, say 24 months for completion of the work of construction on the said plot upon revalidation of building permit by KMC, and in this regard, informed of the charges payable, if any, therefore, excluding the period covered by the above judgment and order of 25/9/2020 of the Honorable Calcutta High Court, until your good self finally takes a decision in the matter following the same. Informed about the annual licensing fee and other charges, if any, in areas to effect payment thereof. From the official records, it appears that first, my lord, on the land is allotted. Then para 2 is payment certificate, para 3 permissive possession, para 4 license deed executed, then para 5 again license deed, then 6 is NOC for mortgaging, 7 is, my lord, except boundary wall, nothing done, but the land is vacant. Then para 8 is documents relating to the project implementation schedule. Then para 9, after paragraph 8, kindly take para 9. VDA memo number, so dated 23/3/2010, KMD had asked the allottee for submission of documents like proposed building plan, NOC of the fire, pollution, mutation, and building permit. Further, VDA memo dated 6/5/2010, KMD called upon the allottee petitioner for a hearing on such and such. I showed that. Then para 11 again hearing, para 12 again hearing, para 13 they prayed for a fresh hearing, then para 14 called for a hearing, then para 15. As per the order sheet of hearing dated 10/9/2010, the matter was referred for cancellation of allotment. The matter was placed for the 15th Land and Flat Allotment Committee of KMDA held on 23/11/2010, wherein the committee ratified the decision of cancellation of allotment of block land plot allotted to Messrs. Bajoria, and the said decision was duly approved by the authority in its 165th meeting held on so and so. Accordingly, it is evident that the allottee petitioner failed to start construction as per meeting of KMDA held on 23/11 and subsequently approved on 165th meeting held on 12/1, the matter is required to be placed before the next authority meeting of KMDA to achieve as an independent decision on the merits with respect to the prayer of the allotment, prayer of the allottee petitioner. Then, my lord, it is placed on 26/4/2022. Which is at page, my lord, 71.
Yes.
My lord, the relevant portion is paragraph, at page 72, agenda item number 39. Prayer for extension of time for completion of the construction work by revocation and cancellation of payment of outstanding dues of plot number, etc., in respect of allotment of plot by KMD to Bajoria. Decision: the authority has examined the matter and decided that the allotment stands cancelled. Action so and so. Now here, thereafter, my lord, challenging, my lord, this memo at page 70 of my opposition, my lord, the parties are before this honorable court. Now, my lord, these are the sequence of facts.
So no opportunity of hearing was given to the petitioner prior to cancellation.
No. Prior to that, my lord, it was given. My lord, please come back to, my lord, the order of this honorable court, which is, yes. Yes. But 63,
yes,
the relevant portion, which I have placed, fifth line of that paragraph. Since the KMDA will examine on merits the ground realities qua the OMH as existing on 24th November 2009. This is what, my lord, we were to consider. Now, my lord, this was, my lord, the direction of the court. Now, post disposal by the this honorable court, my lord, page 64, my lord, I have not placed of my affidavit in opposition. No, I'm sorry. Yes, yes. My lord, at page 65. The third line from the top, in compliance with the order of so-and-so in WP so-and-so, hearing was called on 23/12/2021.
So it was attended by the deputy.
Yes, and Miller, they filed a representation that your lordship would find from the 4th paragraph.
Yes.
Hearing given. Miller, the
Paragraph 25.
please take paragraph 25 of the writ petition. Where it is their averment. In the meantime, KMC sanctioned the building permit bearing number, etc. on 13th of June 2011. It's P18 at page 241.
Page 41.
241. Para 25, annexure P18 they have referred, which is at page 241.
Yes.
Issue of sanction stroke provisional sanction of erection, re-erection, addition to or alteration of building under such and such.
There are certain conditions laid down in the bottom of this document, 241.
Yes, madam. But these are, Miller, the normal conditions, Miller, which are imposed in all Miller sanctions.
So receipt of the sanction plan was also required.
Receipt of the sanction plan.
Sanction plan was also necessary.
Yes, yes.
Prior to commencement of construction.
Yes, yes, definitely. Miller, the system, as your lordship knows, Miller, if I submit a building plan for sanction, first, Miller, there is a committee which is constituted of various Miller representatives of various departments like fire, TICA, etc., etc. Now, Miller, they sit in a meeting and decide whether or not to give a sanction. Now, if they decide not to give sanction, the matter ends over there. If they decide to give a sanction, then, Miller, the building permit fee is calculated. After the building permit fee is calculated, then it is communicated to the person or the applicant that plan where there's a decision to sanction. Now, X amount is your building permit fee, and XYZ, Miller, there are other charges. You deposit it and take the sanction plan. Then, Miller, thereafter, Miller, the person goes, deposits the sanction fees or building permit fee and gets the sanction plan. So now, this is an intimation in respect of that. And my lord, as your lordship knows, these are they have got certain conditions like, please take the last condition at page 242. Or the condition number 6. The building work for which this building permit is issued shall be completed within 13 June 2016. So nothing done. And kindly see the application, date of application at page 241, first line. With reference to your application dated 9th December 2010. But these are all much long after that I give the first notice of hearing. My first notice of hearing is on 10th of November 2009. So by that time they had applied for sanction. Milord, the period mentioned in the license deed expired. I had issued a notice. In fact, I had issued 1, 2, 3, 4. All the notices prior to that. Prior to 9th December, I had issued 4 hearing notices. First one is on 10th of November 2009. Second, 23rd of March 2009. Third, 6th of May 2009. And the last in that sequence is 4th of June 2010. So there was no compliance with the conditions prescribed in the deed of license. Therefore, my lord, please consider, my lord, in this background, my lord, whether, my lord, any interference is called for in regard to the cancellation of the allotment as well as the deed of license. My lord, on the legal aspect, my lord, first is, the first document shows that I have given them permissive possession. Now, as your lordships know, my lord, in a case of permissive possession, the juridical possession, my lord, remains with the owner of the land. Therefore, no possessory right like a lease is conferred by way of a permissive possession. Now, my lord, 1 or 2 decisions on that. I'll tell you, lordship, my lord, the outlines of my argument. First is on permissive possession, my lord, no right was conferred to them under the deed of license. Number 2 is, as I have also drawn your lordship's attention that, my lord, no lease deed was executed. And the fact is no lease deed is as of date executed. Therefore, no possessory right as on this date was conferred upon the respondent. Upon the petitioner. My lord, third is, right to re-enter, my lord, reserved in the license deed itself. Fourth is, my lord, in a contractual matter, which is out and out, my lord, a private contract, my lord, this cannot be enforced before the writ court. And, my lord, finally, my lord, in the absence of any legal right, well, no mandamus can be sought for. Because you need to have a legal right to enforce it before a writ court. Now, my lord, before going into all these, but to cut short, these kinds of cases, my lord, has been decided by this honorable court. My learned friend, Mr. Mitro, was referring to 1 or 2 decisions. Now, please have a look to, my lord, at the judgment of the division bench, which has approved a judgment of my lord in Damodar Prasad Agarwal. But first, my lord, I place my lord's judgment. But this is in WPA 3443 of 2019, delivered on 10th of February 2022.
Yes.
But please take the 8th page of the judgment. But this was a case of lease. Ours is a better case so far as I am concerned. In the case in hand, both the parties are governed by the deed of lease entered on so and so. Admittedly, the petitioner failed to raise construction in the demised land within 5 years from the date of issuance of the deed, in breach of clause 2 III of the deed, and no extension was prayed for before the authority either within the stipulated period of time or at all. It was only when the show cause notice was issued to the petitioner that he woke up from slumber and chose to raise his claim for extension before the authority in the reply submitted by him to the show cause notice. The deed has been cancelled by the authority in terms of clause 4I, irrespective of the claim of penal charges by the authority. Even if the claim for penal charges is ignored, the authority still had the right to cancel the deed in terms of clause I thereof, and as such, the authority has acted well within its right and jurisdiction. As pointed out by learned counsel for the respondents, acceptance of license fee by the authority till 2010 does not preclude the authority from cancelling the deed in view of clause 4 III of the deed, which indicates that any relaxation or indulgence granted by the authority to the licensee or by the said licensee to the authority shall not in any way prejudice the rights of the parties under this deed of license. It is also submitted that the authority has taken steps for refund of the premium, etc. In view of the above, this court is of the view that there is no illegality or irregularity in the act of the respondent authority which calls for intervention of this court in the present writ petition, and as such, the writ petition is devoid of any merit and dismissed. Now, this went up to the appeal court. With the division bench, Millard, of Honorable Justice Arijit Banerjee and Honorable Justice Rai Chattopadhyay, Millard, was considering, where it's the Honorable Judges, Millard, have delivered separate judgments. First, Millard, of Justice Rai Chattopadhyay, Millard, please take, Millard, paragraph, page 19. Or if I may start from page 18 bottom. Under these facts and circumstances, change in policy made by the concerned authority, change by the authority in the midst of the period of subsistence of the agreement between the parties and its implementation cannot be held to be improper or illegal. There is no doubt about the correctness of the findings of the learned single judge that the respondent's action of termination of the lease deed falls within the purview of the terms and conditions of the contract entered into between the parties upon fulfillment of the terms of the covenant, and irrespective of payment or non-payment of penal charges by the appellant. Even the appellants could not have embraced success had their allotment been terminated due to non-payment of the said penal charges. Needless to mention here that the terms of the license deed dated so and so have independent application in case of violation as stipulated and would not necessarily require to be qualified with any further conditions. Discussions as above would indicate that the findings of this court regarding the legality and propriety of the judgment of the learned single judge dated so and so, and the same is hereby affirmed. Then Millard, Justice Banerjee delivers a separate judgment, Millard, only adding to the what should I say, Millard, the reasons. Please take page 22, para 4. May I seek an indulgence, Millard? I've got a matter fixed at 4:20.
Continue some other day.
Millard, let this judgment be placed by Mr. Talukdar, Millard. I'll come back on some other.
Can you conclude?
No, Millard, I need to, Millard, this is to shorten the issue. But Millard, the principal issues, Millard, I would place one judgment each on each points without multiplying judgments. But since this being decided, I thought, Millard, I place this judgment first and then, Millard, kindly give me this. I'm grateful.
Only I shall be placing this.
Yes. Just let him finish this.
Other point, Mr.
Yes, I'll come back on the next. I'm grateful.
Page 22, para 4.
Mr. Dattu,
Yes, yes.
the relationship between the appellant and KMDA was purely contractual. The appellant was admittedly in breach of a contractual term. The contract license deed authorized KMDA to cancel the license deed upon breach by the appellant of any of the covenants in the license deed. KMDA exercised such right and cancelled the license deed. Prior thereto, in terms of a policy formulated by KMDA, it agreed to accede to the appellant's request for extension of time for making construction upon payment of penal charges. The appellant pleaded inability to pay such charges. Thereupon, KMDA cancelled the license. In my opinion, KMDA need not have shown any indulgence to the appellant, and the indulgence shown did not in any way affect its contractual right to terminate the license. While operating in the realm of a private contract having no statutory flavor, like in the present case, the state or a statutory authority should be allowed to act as any other private party, and their action should not be interfered with lightly as being unreasonable or arbitrary. The competent authority in KMDA has framed a schedule of charges to be levied on defaulting allottees of land as a precondition for extension of time to make construction. It is a financial policy of a statutory authority with which the writ court should not easily interfere. The schedule of charges in terms whereof KMDA demanded money from the appellant for granting extension of time to make construction is not under challenge in the present proceeding. There is also a clause in the license deed to the effect that any relaxation granted or indulgence shown by KMDA to the licensee shall not in any way prejudice the rights of the parties under the license deed. KMDA offered to extend time for construction against payment of charges. Such offer was not accepted. This indulgence shown by KMDA in no manner affected its right to repossess the land in question upon termination of the license, in view of the appellant's failure to make construction on the land within the contractually stipulated period or even much beyond such time. Accordingly, in my considered view, there is no infirmity in the order under appeal. The appeal deserves to be and is dismissed, interim order, if any stands by. Well, this order was again, my lord, carried to the Honorable Supreme Court. The SLP was dismissed. I have to copy that. So this is from your lordship's order, division bench and the Supreme Court. The two parts, even if the panel, it is cancellation is independent. My lord, I should not open any other point.
So will you continue some other day in that case?
Yes, it is better, my lord, when
Yes,
Mr.
my lord. Any day, well, sometime.
Mr. Datta will not take much time. He will cite some judgments.
Come back after that, I'm afraid.
My lord will fix the date, my lord, then
I will.
date.
Third learned counsels for the parties.
Good.
Paragraph, let the matter appear under the same heading for further consideration on 22nd August,
My lord, at 3:30.
3:30.
At same time,
Same time.
mock test,
22nd August, marked at 3:30.
mock test.
My lord, the interim order already passed has to be extended. It's up to 31st July.
Till 31st August. Paragraph, the interim order granted earlier is extended till 31st August or until further orders, comma, whichever is earlier.
It has to be when your lordship is hearing this.
Since we are hearing of the
Yes,
matter,
Yes,
so-
I'm obliged, my lord.
এটা